How do I? Says he's host. My computer is muted.
All right, it looks like we are ready to proceed, so we're good to go. Thanks.
Okay, great. All right. Once again, good morning, everyone. I hope that all of you had a pretty good September thus far, and of course, happy fall to all of you. Before we get started, if you see me looking to my right, I'm going to be reading just the opening remarks as the board chair. So I'm not staring off into space. I'm actually just reading off my iPad. It'll be easier for me here. So with that, we'll get started. The September 28th, 2021 meeting of the Charlotte Zoning Board of Adjustment is now in session. I am Douglas Wilson, Chairman. Also sitting on today's board is Krista Long, John Floyd, and Marshall Williamson. Also present are Shad Spencer, our zoning administrator, Lisa McCarter, our planning project manager, Terry Hagler Gray, our senior assistant city attorney, Jill Sanchez Myers, our senior assistant city attorney, Terry Edwards, clerk to the board, and Adkins, court reporting verbatim reporter. I would like to start by acknowledging that we are conducting this meeting using a remote electronic platform. This is the 15th remote meeting of the Charlotte Zoning Board of Adjustment, and I would like to ask for your patience today as we proceed. There may be slight delays as we transition between speakers, participants, and presentations. The Zoning Board of Adjustment is a quasi-judicial board that is governed by the North Carolina General Statute and the Charlotte Zoning Ordinance. We conduct evidentiary hearings on a request for variance and appeals, among other requests. Before we begin to hear the cases on today's agenda, I would like to provide some important information on the steps that we're taking to ensure that each party's due process rights are protected as we proceed in this remote platform. First, today's meeting will be conducted in accordance with special legislation passed by the North Carolina General Assembly in Session Law 2020-3 that allow for remote meetings and quasi-judicial hearings during declarations of emergency. Second, each applicant was notified before being placed on today's agenda that this meeting will be conducted using a remote electronic platform. Every applicant on today's agenda has provided signed consent to the board prior to conducting the evidentiary hearing on their requests using this remote platform. Third, notice of this meeting was provided to the applicants and the public in several ways. Notice of today's hearing was mailed to property owners within 300 feet of each subject property and notified the property owners of the remote electronic platform, and the letter also stated to contact the city immediately if there were any objections to the cases being heard of today's agendas. Notice was also provided by placing signs on each property and by publishing notice on the city's website. The notices for today's meeting contain information about means by which the public can assess today's proceedings. Finally, any individual wishing to participate in today's evidentiary hearings were required to sign up prior to today's proceedings. This information was also included on the board's website. Number 3, hearing. Application for a variance from the regulations in the zoning ordinance. The application for a variance from the regulation under the zoning ordinance, the order of the recommendation agenda will be as follows. The zoning administrator or a zoning staff member will identify the case and recommend approval of the variance with any recommended conditions based on specific reasons. The chairperson will ask if anyone wants to speak in opposition. If there is such a person, then the case will be moved to the regular agenda and will be heard at a later date. The chairperson will ask if the board has questions for staff or if there is any reason the board wishes to move the case to the regular agenda. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. The order of the agenda will be as follows. All parties who plan to give testimony, pro or con, must be sworn in. A zoning staff member will explain why a permit was denied or why a variance is requested. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for this case. The board may question the applicant, and the staff member may also question the applicant. The applicant may present sworn witness. They will be subject to questioning. Other parties wishing to speak, pro or con, will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each regular agenda case. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. All exhibits must remain with the board. Exhibits were required to be provided to the clerk no later than 12 p.m. on Monday, September 27th, in order to be considered at this hearing. If your case is not appealed to the Superior Court after 30 days, you may pick them up or they will be destroyed. If you feel there is a conflict of interest of any member of the board or an association that would prejudice your case, please let it be known at the start of your case. The board is acting in a quasi-judicial capacity for purposes of this hearing and can only accept sworn testimony. While the board will not specifically exclude hearsay evidence, it is only given limited weight. The North Carolina State Bar has issued an advisory opinion that it is the unauthorized practice of law for an individual who is not an active member of the bar to appear for another or otherwise assist or represent another at quasi-judicial hearings on zoning and land use matters. All applicants should have been provided with a copy of that advisory opinion as part of the application packet. If you are a property owner or a non-lawyer here on behalf of a property owner and have not received a copy of that opinion, please use the WebEx platform function to message the clerk for documents will be provided to you. If, as a result of this advisory opinion, the applicant would like to request a continuance of his or her case, the board will consider such request at the start of that case. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal in accordance of the North Carolina General Statute 160A-388E as in Edward. In order to receive a written copy of the decision, any aggrieved party must file a written request for a copy of the board's decision by filling out the form, which must be filled in the board's clerks or chairperson at the time of the hearing of the case. Please remember to mute your microphone when you do not intend to speak. We will hear 5 cases today, 2 recommendation agenda items and 2 regular agenda items and 1 appeal. Clerk to the board will read the names of anyone who opposes a case. I will now swear in and affirm all those parties who plan to give testimony today. And I assume that would be Shad and Lisa. Am I correct?
Yeah, for right now, yeah, it'll be us. And then as we go further along the agenda, there'll probably be other folks that have signed up to speak on other cases. But for right now, it'll just be myself and Lisa.
Okay. All right. So I'll go ahead and swear you guys in. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
All right. Okay. All right. The first case is case number 2021-090, which is 7115 The Plaza, and that will be presented by Ms. Lisa Carter.
Okay, the first variance is a request from the requirement that a medium-sized religious institution can be located on a lot with frontage on a minor or major thoroughfare. And I'll give you a minute to look over your findings.
And board members, those findings were sent by Terry, I believe, around 8:30 or 8:40 this morning, so it should be in your email if you haven't had a chance to look at them. Okay, Lisa, you may proceed.
All right, exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map of the property. The zoning of the property is R4 single family, surrounded by other R4 single family, and there is some business zoning along the plaza. Exhibit 3 is an aerial map of the property. You can see from the aerial view that the lot has frontage along St. John's Church Road, and there's access from the plaza. There's currently a church and cemetery on the property. Exhibit number 4 is a close-up aerial of the property. Exhibit number 5 is background. Per the zoning ordinance requirements, medium-sized religious institutions are permitted in the R4 zoning district on lots with frontage on a major or minor thoroughfare. The existing church building on the property was constructed in 1999, and the site was compliant with the frontage requirements at that time because the lot had frontage along the plaza, which is a major thoroughfare. You can see the previous lot configuration from a 1985 records map on the top left. In 2016, the property's frontage along the plaza was sold to QT, who rezoned the property for a convenience store, leaving the easement for access to the church property. Exhibit number 6 is the variance request. The applicant now wishes to construct a fellowship hall that exceeds the size of the church and requires the site to come into compliance with the thoroughfare frontage requirement. The applicant is requesting a variance to construct the new fellowship hall on the property. So on this map, you can see outlined in green is the current parcel configuration. The yellow is the proposed fellowship hall, And you can see the frontage along St. John's Church Road and that easement down to the plaza. Exhibit number 7 is considerations. Staff supports the requested variance. The hardship was not caused by the applicant because the applicant purchased the property after the previous owner sold the property's frontage along the plaza. The hardship results from conditions peculiar to the property because the existing church and cemetery on the parcel are oriented towards the plaza, and the primary vehicular access is from the easement off the plaza. The requested variance is consistent with the spirit and intent of the zoning ordinance because the site has been in use as a religious institution since the 1970s, and the variance request will allow the use to continue. There are no safety concerns with the granting of the variance and construction of the fellowship hall because the plaza easement will remain as the primary vehicular access. Exhibit number 8 is photos. On the top left, you can see a view of the property looking from the plaza. And if you look towards the middle, there's a truck there, and that's actually the parking lot to the church. The top right photo is the driveway from the QT parking lot access. The lower photo is the rear of the property with frontage along St. John's Church Road. And you can see from this photo that the St. John's Church Road frontage is not used to access the site. That's the end of my presentation, and I'd be happy to address any questions that you have for me.
Okay, great. Thank you, Lisa. Terry, has anyone signed up in opposition against this case or for this case?
No, sir. Mr. Douglas, no one has signed up for opposition.
Okay, great. Does the board have any questions for staff? All right, great. And is there a motion to approve or deny the variance?
Long makes a motion to approve.
Okay, motion has been moved to approve the variance by Krista Long. Is there a second?
Second by John Floyd.
Okay, the motion has been seconded by John Floyd. Now we move into a period of vote. Mr. Floyd?
Floyd, yes.
Okay, Ms. Long?
Long, yes.
Okay, Mr. Williamson?
Williamson, yes.
Okay, and Wilson, yes. Okay.
Mr. Wilson, don't we have a fifth member on the board?
You know, John, I'm not sure if they are present. I think we only have like 4 members today.
No, Doug,
But,
I'm here too. Raghu also here.
My apologies, Raghu. I'm
No
so sorry
worries.
about that. I was looking at my notes. How do you vote on this case?
Yes, please.
Okay, great. Mr. Raghu, yes. Okay.
And Mr. Chair, if I may?
Yes, ma'am. Yes.
This is Jill Sanchez Myers, attorney for the board. Mr. Raghu, if you could just state or clarify for the record that you were present during the entire presentation of this case. Is that
I
correct?
I was there from the moment the Zoom meeting started. Yeah.
Thank you.
Yes, and that's my mistake. I heard Mr. Raghu come on, but I didn't have his name on my notes here. So just for the record, we've had him since the beginning of this presentation. All right, great. So the variance has been approved. Now we can look at the findings and facts of law. Has anybody on the board found any discrepancies in it that need to be changed, or can we have a motion to approve the findings of fact of law?
Williamson, I'll make a motion to approve the findings of fact.
Okay, motion has been made by Mr. Williamson to approve the findings of fact of law. Is there a second?
John
Long
Floyd, second.
Okay, there's been a second by Mr. Floyd. Now we move into a period of voting. Mr. Floyd,
Floyd, yes.
Ms. Long,
Long, yes.
Mr. Williamson,
Williamson, yes.
And Mr. Raghu.
Raghu is yes.
All right, and Wilson, yes. The findings of fact of law have been approved. Now we move to our next case on the agenda. This is case number, recommendation agenda, case number 2021-094. Lisa?
All right, give me one moment.
Sure thing.
All right, this is a case for a transitional setback variance. The applicant is requesting a variance to allow for the maneuvering of vehicles within the proposed right-of-way and transitional setback along Wilkinson Boulevard. And I'll give you a minute to look over your findings.
Okay, Lisa, you may proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map of the property. The property is zoned B2, general business. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. You can see the parking area located along Wilkinson Boulevard. Exhibit number 5 is the background of the property. There's currently a non-conforming auto repair garage on the property, and it was constructed in 1955. It predates the zoning ordinance requirements. Wilkinson Boulevard has an existing right-of-way that varies from about 45 feet to 50 feet from the center line. The applicant wishes to renovate the parking area, which will then be subject to the proposed right-of-way regulations for Wilkinson Boulevard, which is a Class 3 commercial arterial. So this is the existing condition. Exhibit number 6 is the variance request. The proposed right-of-way for a Class 3C thoroughfare like Wilkinson Boulevard is measured 75 feet from the street center line. There's a 20-foot transitional setback for the B2 zoning district that's measured from that proposed right-of-way. So you can see these hatched lines. There's the 75-foot right-of-way, the proposed right-of-way, and then the 20-foot setback from that proposed right-of-way, which is the transitional setback. You can see from the applicant's proposed site plan, the majority of the parking and maneuvering on the site is currently located within the proposed right-of-way and transitional setback area. The code doesn't permit the maneuvering of vehicles in the transitional setback or proposed right-of-way. The applicant is requesting a variance to allow the maneuvering of vehicles within the proposed right-of-way and transitional setback along Wilkinson Boulevard. So this is the proposed site plan overlaid on the aerial map, and you can see the driveway and maneuvering area that's more clearly defined. Exhibit number 7 is considerations. Staff supports the requested variance. The hardship's not a result of actions taken by the applicant because the site was developed in 1955, and current parking and maneuvering space encroaches into the proposed right-of-way and transitional setback area. The proposed request meets the spirit and intent of the zoning ordinance because proposed changes would bring the parking lot further into compliance by eliminating the existing encroachment of parking spaces into the proposed right-of-way and transitional setback. The Charlotte Department of Transportation and North Carolina Department of Transportation were both notified and did not have comments on the requested variance. The Charlotte Area Transit System has no objection because the Future Link Silver Line is not in this section of Wilkinson Boulevard. Granting the variance will not adversely affect adjacent or contiguous properties or alter the character of the area because many properties along Wilkinson Boulevard have parking areas that encroach into the required setback and transitional setback. The variance will not impact public safety and the proposed parking lot will be safer, providing more clearly delineated spaces and drive aisles. Exhibit number 8 is photos. The top left photo shows a corner view of the property, and the street side view is on the top right. The bottom photo shows a view of the property from Wilkinson Boulevard. And that's the end of my presentation. I'd be happy to address any questions that you have.
Okay, great. Thank you, Lisa. Has anyone, Terry, has anyone signed up to speak against this case or for this case?
No, Chair Douglas, no one has signed up in opposition.
Great. Members of the board, do you have any questions for Lisa about her presentation? Okay. Okay, if not, is there a motion to approve or deny this variance?
Williamson, motion to approve. This seems to make sense.
Yeah, I will second that.
Great. Motion has been moved for approval by Mr. Williamson and seconded by Mr. Ragu. Now we will do a roll call vote. Mr. Ragu,
Yes, please.
okay. Mr. Williamson,
Yes.
okay. Mr. Floyd,
Floyd, yes.
okay, and Ms. Long,
Long, yes.
right, and Wilson, yes. The motion has been approved and the variance has been approved. Now we will go to our findings of fact. And I didn't see anything. I'm not sure if anybody on the board may have caught anything that I may have missed, any grammatical errors, anything like that, but it looks fine to me. Okay. Is there a motion to approve the findings of fact?
I will make a motion to approve the findings and facts.
And Long seconds.
All right. Motion to approve the findings of fact was moved by Mr. Ragu and seconded by Ms. Long. Now we'll have a roll call vote. Ms. Long?
Long, yes.
Okay. Mr. Floyd?
Floyd, yes.
Mr. Ragu?
Ragu, yes.
Mr. Williamson?
Williamson, yes.
Okay, and Wilson, yes. Okay. Now we are moving to our regular agenda. Our next case is case number 2021-089. All right, Lisa.
The next case is a residential setback variance. The applicant is requesting a 15-foot variance from the 30-foot setback for the construction of a duplex unit facing Willow Oak Road. And I'll give you a moment to look over your findings.
Okay, Lisa, you may proceed.
Okay, exhibit number 1 is a vicinity map of the subject property. Exhibit number 2 is a zoning map of the property. The property is zoned R4, single-family residential. Exhibit number 3 is an aerial map of the property. The property is vacant and located at the corner of Willow Oak Road and Towns Road. Exhibit number 4 is a close-up aerial of the property. Exhibit number 5 is background. In June of this year, the applicant obtained a building permit to construct a duplex dwelling on the property. The permit specified that there was a 15-foot setback along Towns Road. The plot plan showing the proposed duplex also showed a 15-foot setback along Towns Road. Exhibit number 6 is background. Although a 15-foot street side yard would be required for a single-family home, a duplex requires the condition of being on a corner lot and being subject to the 30-foot setback along both streets. In July, a notice of violation was issued when a code enforcement officer saw from a field observation that the duplex was encroaching into the required 30-foot setback on Towns Road. Exhibit number 7 is the variance request. The applicant is requesting a 15-foot variance from the 30-foot setback along Towns Road for the construction of the dwelling unit within the duplex, which fronts along Willow Oak Road. So you can see here from these graphics, the first one over on the left side is the permitted layout. And then on the right side is the proposed compromised layout where they're scooting the back unit that faces Towns Road back to comply with the 30-foot setback. Exhibit number 8 is considerations. The hardship is not a result of actions taken by the applicant because city staff provided incorrect information about the Towns Road setback. The applicant wasn't aware of the 30-foot setback requirement for Towns Road until they received a notice of violation. At that point, the applicant had began construction and extended substantial resources on the unit facing Willow Oak Road. The applicant has agreed to construct the dwelling unit facing Town Road in compliance with 30-foot setback as a compromise, since the site work for that unit was not as extensive. In granting a variance, public safety is secured and substantial justice is achieved. The hardship is unique to the property because the lot is a corner lot, and the applicant states it is one of the only corner lots on Willow Oak Road with sufficient area to support a duplex. The duplex on this subject corner lot requires a greater street side yard dimension that is twice the dimension of the street side yard required for a single-family dwelling on a corner lot. From the aerial of the property on the lower right, you can see the lot located directly across Towns Road that would be the most impacted by this request, and it's undevelopable due to its width being only 20 feet. The proposed placement of the duplex on the subject property will meet the spirit and intent of the zoning ordinance by having the dwelling unit facing Towns Road step back to the required 30-foot setback dimension to align with the required setbacks of the single-family homes further east along the street. The requested variance is in harmony with the intent of the zoning ordinance, which permits duplexes on corner lots in the R4 zoning district. Exhibit number 9 is a photo, and you can see that site work has been done. Footings have been poured for the unit facing Willow Oak Road. And that's the end of my presentation. If you have any questions for me, the applicants also prepared a presentation, and I believe there are people signed up to speak in opposition, and there's a presentation that has been submitted by some of those opposed to the request.
Okay, thank you, Lisa, for your presentation. Before we get to the applicant and those who have signed up in opposition, does the board have any questions for Lisa or for staff regarding this presentation? All right. So Terry, I know that we have folks that have signed up to speak for and against this case. Just have a question. How many folks do we have? And Jill, Ms. Sanchez-Myers, excuse me, my question for you is, am I able to just swear all of them in at one time, or do I have to swear them in individually as they come up to speak?
Sure, you can swear them in at one time, all of those who are available.
Okay.
And then, but I would just make sure to verify before each speaker, it comes to their turn to present, just verify that they were in fact sworn. And if not, you make sure that they do get sworn.
Okay, great, thank you. And Terry, do we have any attorneys present with folks who have signed up to speak for or in opposition? I just want to make sure that we know that the attorneys do not have to be sworn in if they are present.
Yes, Chair Douglas, we have David Murray here on behalf of Brent Bowers with JAS-AM Inc. And then we also have in opposition Nancy Lithock and Representation Counsel for the community.
Okay, great. And are the attorneys doing the presentation or the applicants and the opposition members doing their own presentation?
Both sides will have presentation.
Okay, great. All right. So I guess we will go first. You know, whoever is ready to go. I'm not sure if there's a particular order, but just let me know and I can go ahead and swear these folks in.
We have the applicant's presentation first up.
Okay, all right, perfect. Okay. Is the applicant is their line open? I just saw some, I think I saw him in the chat.
David, you should be a panelist now.
Thank you. Also, my client is John Bowers. Brent Bowers, and he needs to be made a panelist because he's going to present with me.
Okay. Thank you, Mr. Murray. You say his name is John Bowers?
Sorry, Brent Bowers.
Brett Bowers. Okay. All right. Terry, just let me know when Mr. Bowers' line is available, and I can go ahead and swear him in.
Brent, you can unmute.
Brent's in now.
Okay. Mr. Bowers, can you hear me?
I can, thank you.
All right, great. Good morning. I just need to swear you in. Do you swear to tell the truth, the whole truth, and nothing but truth in the matter at hand?
I do.
All right, thank you very much. Okay, Mr. Murray and Mr. Bowers, you can go ahead with your presentation.
Thank you, sir. Mr. Chairman, I also swear, even though I know a lot of boards don't swear in lawyers, oftentimes I am, given argument, testimony, and factual information. So I always like to confirm that I'm also swearing in here too. Lisa, if you could start my presentation. Thank you. Members of the board, again, my name is David Murray. I'm an attorney with the Odom firm here in Charlotte. I represent Sam Incorporated with Mr. Brent Bowers here. The property address is 3235 Willow Oak Road, as you can see in that aerial. You can move forward. The variance request here is so that construction can continue for a duplex that's facing Willow Oak Road. It began under a properly issued permit after conversations with the city confirming a 15-foot setback on Towns Road. The setback is actually 30 feet, as Lisa said, and I want to again thank Lisa for her presentation because I think she covered basically everything the property owners need to show here to obtain this variance. But like I said, we're going through this presentation just to reinforce that. We understand now that the permit was mistakenly issued. As far as site work goes, a retaining wall, as you'll see with pictures, has been installed, and grading for the footings had been undertaken for only the front unit. So we're not here trying to get a variance for the back unit also. It's only for the front unit, because that's where the main part of construction and grading and site work had taken place on this property. That's the only portion of this that was done under the permit before the city notified us that there was an issue. And so the main focus here is on the fact that the applicants were proceeding in good faith under that permit. And when they proceed in good faith, a variance should be granted. Forward, please. As far as the timeline goes, prior to closing and due diligence, the owner inquired with the planning department about how they would apply the setback for a duplex. Again, They were informed 15 feet. They submitted permit applications in June of this year. Permits were issued late June of this year. They realized that they needed and what really kind of triggered this was they needed a permit for the detached garage on the rear duplex unit that faces Towns Road. And when they went to get that permit, that's when the review officer, Lovely Bell, saw the application and realized that there's an issue with the setback that was shown. So on that same date, Sonja Sanders from the zoning department contacted JASM and advised them that the permits and what the applicants had been told about a 15-foot side yard was not correct. And so they would have to stop construction. In compliance with that, my clients immediately stopped construction. So they did not proceed. There's been nothing done since then. They've abided by what the city's done. We had a meeting with the city and we proceeded to apply for this variance. Next slide, please. The cost that they've incurred with design, because they designed this based upon a 15-foot side yard on Towns Road. The retaining wall is because to build down to 15 feet on Towns Road, there's a substantial amount of grading that need to be undertaken. The site fell approximately 10 feet from the adjacent property owner down to Towns Road. And so a substantial amount of money was expended in reliance upon this setback. Next step. As you can see here, and Lisa mentioned this before in her presentation, the area of the variance is approximately where the arrow is pointed. And across Towns Road is what we're calling a buffer tract that's actually owned by the applicants. And from what we can gather is all this was all one parcel years ago. And when Towns Road was eventually added to build that cul-de-sac, it subdivided a portion of this parcel off. And so the owner that they purchased this property from also owned the buffer tract. So the buffer tract came along with this tract. And that's important because the owners to the south of the buffer tract, I've had some communications with them. I don't know if they're on this call today, but their main concern was that that buffer tract would stay intact. And it's within a creek buffer. So the trees cannot be removed there. And so it provides a natural buffer to any building that's along Towns Road. And so the parcels that are directly, that back up to this the most, they actually have a buffer tract in between them and this parcel. And that's really important, as Lisa said, for conformity with the neighborhood and any effect on any adjacent properties. As you can see across Towns Road, the stream carries on across Towns Road. So there's a buffer over there too. So no house can be built in that area because the buffer carries along across Towns Road. So as far as any further development goes, the buffer tract will never have anything constructed, and the area across Towns where the stream is, and basically between those two red arrows, is where the existing stream buffer runs. This is our Exhibit 1. Thank you. Next one. As you can see, the topography falls from 630 feet down to 620 feet and required substantial grading in order to grade down to Towns Road for the house. Next slide, please. And this is the proposed plat that was submitted for the permits, as the city has already shown in their presentation. Shows a 15-foot side yard, 30-foot front setback. So keep in mind, on Willow Oak, there's no difference in the setback. The setback is the same for Willow Oak. It's only a focus on what's going on Towns Road, which is the road that has the buffer across the street. Next slide, please. This is the permit. Again, the city's already submitted this into evidence, but just to show this is very detailed for a permit. Typically, you see a hand-drawn permit, a hand-drawn plot plan, but they actually put the structure itself showing exactly where the setbacks would be. They showed a 15-foot setback from Towns Road. The structure itself is not exactly on the 15-foot line, but it's close. And this is what was submitted. Next slide, please. This is an enlargement to show, it's showing a 15-foot side yard on the Towns Road. This is what was enlarged from the application for the permit. Next slide, please. This is the actual building permit that was issued. As you notice, it says right side 15 feet. The permit is for a duplex. And the permit notes zoning setbacks listed on the permits for the footprint of the entire building. Both units must be in compliance with the limits of the building footprint setbacks. And so, as you can see, the permit had the 15-foot setback shown on there. Next slide, please. This is the review notes, plan review notes, and as you'll see, underlined where it says setback notes, plot plan appears to be in compliance. So this was after zoning plan review. There again was no one called out any issue when the permit was issued. Next slide. At this time, I'll have Mr. Bowers come on and introduce himself. Brent, if you can just quickly tell the board your connection to JASAM and this project.
Hi, good morning. My name is Brent Bowers, and I am one of the management team at JASAM Incorporated. Do a lot of the field supervision, and we're a small business, so usually do the permitting and that sort of thing. So very active on all of our projects.
And Brent, I usually ask this at the beginning, but I'll ask it now. You have reviewed the application and the PowerPoint that I'm using here, correct?
Yes.
And they are accurate to your knowledge. Is that accurate?
That's true.
Okay. And you've retained me to testify on behalf of JASAM in this case. Is that correct?
Yes.
Yes. Okay. Now, Brent, what I'll have you do is there's a series of pictures that are going to be coming up, and I would ask for you to just describe to the board what is shown in these pictures as we go through them so that they're aware of what's actually taking place on this site.
Okay, this is some of the initial grading of the unit that is facing Willow Oak. You can see the excavator there that parked on the left of the site, and we're viewing from Towns Road here.
Next slide, please.
This is the neighbor along Willow Oak where we were building the retaining wall to allow us to build with the topography that David described, which is the 10-foot drop from the neighboring property down to Towns Road. So we built this this tall wall here to retain that so that we can build the permitted structure as we had planned.
And just for the record, the previous slide was Exhibit 8. The one you just described is Exhibit 9. Okay. If we could go to Exhibit 10, please.
This is just another picture from Willow Oak, just showing the machine on site. And this is right around the time that, I think we might have just received the stop work notice in this time frame somewhere here.
All right, if we could go to exhibit number 11, please.
This is some of the kind of the site as it sets. We've got a lot of water standing because we don't have the grade, the foundation completed, and so it's just kind of deteriorating a little bit with water standing in this soil area that we're trying to that we've already graded in that area. So
And Brett, this was dug out for the location of the footings.
Yeah, so what we do, the footings, it's almost like yeah, so this is the footing footprint for that Willow Oak unit. So essentially, it's almost like a short basement. You have all this that essentially looks like the footprint of the structure that it is there carved into the land. So it's very specific in that we, if we don't put that in the right spot or we end up having soil conditions underneath there that are not suitable for, future development. So this is very specific to that structure and that layout.
Exhibit 12, please.
This is the retaining wall as some progress photos of the rebar and the concrete pour kind of in that area beside the Willow Oak facing unit.
Exhibit 13.
More progress photos of the retaining wall.
Next slide, I think 14.
And these are just some more of the.
Are these some more of where the footings this is for the front unit, correct?
Right, the Willow Oak facing unit. Yeah, this would be the footing areas. Yeah.
Okay. Next slide, please. This is number 15. Again, another similar to what's shown on 14. Is that correct?
Correct.
Okay. Next slide, please. Okay. Number 16 is an aerial showing the general area of this property. And you can see that that the site is one of the few undeveloped sites in this area. You can see the buffer parcel again. You can see kind of how the stream runs across, and then Towns Road runs back into single-family detached structures to the rear. Just so that the board's aware, if you see Geneva Court kind of over on the right side, at the end of Towns Road is actually pretty heavy floodplain area. Geneva Court, I think we've actually done a variance on Geneva Court for no dry land access in the past. So some of those lots that are at the end of Towns Road would have limitations on what they can do just based upon the fact that there's floodplain at the end of towns. Next slide. Again, the city's shown a lot of these, so I know I'm covering, but this is showing generally the extent of where the front unit ran along Towns Road. So this would be the area where it'd be 15 feet. Next slide, please. And then this is where, because again, we're not requesting this variance to allow the second unit to be up against the 15-foot because no site plan construction work was done on the rear unit. And so this is just showing it shifted back to 30 feet. Next slide, please. Number 8. Okay, as I always do, I review the variance standards here because it's important. And I mentioned before, the city's done a presentation. We've now done a very similar presentation. But the standard says that the board shall vary any provisions of the zoning ordinance upon a showing of any of the following. Summarized as unnecessary hardship, conditions peculiar to the property, did not result from actions taken from the applicant or the property owner, and it's consistent with the spirit, purpose, intent of the zoning ordinance such that public safety is secured, substantial justice is achieved. And so when we're looking at these situations, especially when we look back at what this board has approved in the past, when we look at situations where permits are relied upon in good faith, the board routinely has granted these types of variances. Next slide, please. So again, looking at the unnecessary hardship, it results from the owner designing, constructing, completing site work, expending substantial resources, not just spending money, but actually doing the site work, actually grading this site for a very specific structure that was to be built. In order to build this duplex to that 15-foot side yard on Towns Road, immediately prior to pouring, City realized its error, issued a stop work order. No construction has taken place after that. I think in the past, there's been a variance before where someone got a building permit, found out there was a problem, they continued to work. That's not good faith. That's going beyond what would be allowed. These guys have complied with what the city has done across the board. And so when we look at what the North Carolina Supreme Court says, it says a municipality can't be stopped from enforcing its zoning ordinance just because an official allowed that violation, meaning just because there was a permit issued, but it entails a hardship to the property owner. And again, this applies only to the front unit where the construction had begun. Next slide, please. Runs with the land, the corner lot, one of the only corner lots with sufficient size for this duplex. Because the permits had been issued, this wasn't done without permits. It wasn't done without reaching out to the city to get a determination on the side yard. All that was done. So this was not done blindly here. This was done with actual research into determining what the side yard would be. And again, the hardship results from the approval of the permit that was issued and relied upon in good faith. And Brent, can you confirm to the board that all this was done in good faith? Y'all had no reason to believe that the side yard was any more than 15 feet.
Absolutely. I did it myself personally, had all the conversations with the city, and actually filled out all the permit documents, and was directly involved with the planning of the structure based on the information we received from the city.
Next slide, please. Again, the city went through this, and we just dealt with this with Brent's answer. But again, the permits were issued, they were relied upon in good faith. One other thing, and Brent can confirm this also, is that they had built duplexes in the past, but they had always been on R8 zone lots, not corner lots. And in R8 zoning, there is no double setback, as we would call it. And so I think one of the owners that I had spoken with, had a conversation with, she had asked me about that. And so I emailed her just to clarify that they had not built on one of these R3 through R6 before. And that's correct, Brent?
That is correct, yes.
Okay. Next slide, please. Again, conformity with the neighborhood. The neighborhood's primarily detached single family houses. If this was a single family house, it would have a 15-foot side yard on Towns Road. Again, the lot that's closest to this is what we're calling the buffer lot that is owned by JASAM. It's owned by the same as the applicant. So there's no house directly across from this because that buffer will remain there. You know, there, as far as building, actually the use of this property, duplexes are allowed on corner lots. So the duplex use itself is not a question here. It's only the 15 feet for the front unit. That's it. Next slide, please. And again, there's no damage to any adjacent structures because there's not going to be any adjacent structures. The property across the street is a buffer tract, and the rear unit won't even be 15 feet. So it will be 30 feet. So here, when you have a situation where the permit was granted, the owners relied upon it in good faith. They built as soon as the stop work order was issued, they stopped doing construction. And so when we're balancing the interest here, substantial justice weighs in favor of the property owner. Next slide, please. Mr. Bowers and I are here to answer any questions. Brent, can I just have for you to confirm that you fully adopt my statements, my testimony, and my presentation as if it's your testimony in this case?
I do.
Members of the board, we request that you would please grant this variance. Thank you.
Thank you, Mr. Murray and Mr. Bowers, for your presentation. Board members, do you have any questions for Mr. Murray or Mr. Bowers at this time?
Yeah, this is John Floyd. I've got one question, and I don't know if this is better for Mr. Murray or Mr. Bowers, and I think you answered it, but I just wanted to make sure. It sounded like the testimony was that the developer here has not previously developed on a lot that has this type of restrictions. So even though the permit may have had an error, the developer also would not have been aware based on their prior experience that this 30-foot side yard setback was required. Is that correct?
Brent, you can confirm that.
Yes, it is correct. Yeah, our prior development on duplexes was in R8 zoning, which I now understand does not require the double side setback for this. Yes.
Okay, thank you. That's all the question I had.
Thank you, Mr. Floyd. Are there any other questions from the board for Mr. Murray and Mr. Bowers?
No, none from me.
Okay. All right, great. Thank you, Mr. Bowers and Mr. Murray, for your presentation. Terry, do we have anybody else that has signed up to speak for this approval of this variance, or are we going to go now to those who wish to speak in opposition?
We have no further panelists or attendees that are in favor. Everyone else is in opposition. I have that list when you're ready.
Okay. Yes, I'm ready.
Okay, first will be counsel for the community. It's Nancy Litwack. She actually has a presentation. And we also have Larry Lippy, Keys Niemeyer, and David Lawrence.
Okay. All right, so we can go ahead and get started. I need to swear in, and I apologize, the name of the first person. I know that you said that was counsel, but who was the second name that you mentioned?
Nancy Litwack is the counsel. The
Okay.
second is going to be Larry Lippy.
Okay. All right. Mr. Libby, is your line unmuted? Oh, Terry, if he is a panelist. I see Mrs. I'm sorry, Mrs. Litwack. Is that how you pronounce your last name?
It is. I used to be a good old Stewart until I got married, so we can blame my husband on that one.
Okay. All right. Is your client on? I just want to make sure that I swear them in.
Yes, and I represent a few different neighbors in the neighborhood. And just so that you have the names of the people I technically represent, it's Amy Height, Gabe Gerber, Scott Phillip, and Victor Jones. I know that Miss Height is on the line, and I know there are some other neighbors as well who may be speaking, but who I cannot definitively say that I represent.
Okay, all right, great. And Mrs. Height, I'm assuming that she will be would like to speak as well, right? Okay.
That will be up to her once the presentation's over, whether she wants to add or supplement. So not definitely.
Okay. Miss Sanchez Myers, do I or can I wait until after the presentation to swear in her client if she wishes to speak, or do I have to do that before this presentation begins?
No, that's perfectly fine. She can go ahead and present her presentation.
Okay. Okay, perfect. Okay, Mrs. Litwack, so make sure I'm pronouncing your name.
Just like
Litwack.
it looks.
Okay.
Right.
Right,
And
all right.
Mr. Wilson, if you would like to swear me in, just following David's kind of what he had to say, or otherwise I'm happy to submit to the sworn testimony as well.
Okay, for the sake of consistency, I can go ahead and swear you in.
Great.
So do you affirm to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes, I do.
All right, thank you.
Great, thank you so much. And honestly, the presentation that's up on the board, I may not even reference. Those were just some documents I wanted to send to be safe, but members of the board and staff members, thank you so much for hearing us today. Again, I've been retained to represent Amy Height, Gabe Gerber, Scott Phillip, and Victor Jones. These are only 4 of the concerned neighbors who are present and attending today's hearing. But I believe, looking at the participant list, there are a good bit of other neighbors who have shown up today to oppose this request. I think the city and David, it's good to see you again. I think those exhibits really give a good full picture of what y'all need to consider. I'm just going to be arguing the other side of what those exhibits show. So as you've seen, the lot in question is at the corner of Willow Oak Road and Towns. It used to be a small, and here are some pictures that my client has submitted, and you're welcome to go look through them. But I think the city, and quite frankly, David, kind of put up a good bit of them. As we go on and talk about safety and other measures, I might have the presentation proceed. But it used to be a ranch house. JAS AM bought this property on October 28th, 2020, so not even a year ago. For orientation, this property is just south of Freedom Park. It's between Park Road to the west and that Selwyn Queens Road West area to the east. Princeton, that runs just south of Freedom Park, is to the north, and then you've got Hillside to the south. So we're talking about a really affluent neighborhood of Charlotte. There's no doubt about that. And there's no doubt that the duplex built upon this property is going to sell for a pretty penny. So because there was reference to the 2040 comprehensive plan in the application, I just want to note at the outset that we're not talking about affordable housing here. Nor does JAS AM as the builder lend itself to that assumption. JAS AM's website touts itself as a luxury home builder. It actually says on the website, quote, over the past 35 years, the JAS AM Group is proud to have become the Charlotte luxury home builder that the area's most exclusive home builders trust to create their dream homes. With estates in some of Charlotte's top neighborhoods and breathtaking designs featured on national television, the JAS AM Group commands attention throughout Charlotte's luxury home market. So I just want to note that we're talking about a builder who boasts that they've got 35 years of experience and that they're building these luxury homes that are not really lending themselves to that 2040 comprehensive plan theme, which is totally fine. I just bring that up in light of the fact that the application seems to hark back to that. So David mentioned a little bit about the background. About 8 or so months after the purchase, JAS AM applied for a building permit. The permit application itself, and that is a document that was part of the variance request application, notes, and I'll just for reference, this is Exhibit 3 to the permit application, Exhibit 3 to the variance application, and it was JAS AM's permit application. It notes itself that the property is zoned R4. So that's on JAS AM's very own permit application. And let's make sure I clear this up. I know that board member Floyd asked about this. JAS AM is not a new developer in this area. It is not an unsophisticated developer. It knew when it applied for the permit that we had an R4 zone for this property. It has 30 plus years of experience. It knows where to find setback requirements for any particular property. It does not matter that they have not done an R4 property before. You are presumed to know the law, and as someone who's been building homes in Charlotte and dealing with the zoning requirements here for over 30 years, you know where to look. So it's no excuse that they haven't done it in the past. Admittedly, a mistake was made on June 25th when the permit was issued, and it showed the setbacks less than the requisite 30 feet. Just 4 weeks later, on June 26th, as David pointed out, the city realized the mistake, and a stop work order and zoning notice of violation was issued. So this isn't a case where you have the builder developer who've already constructed a home. I've dealt with those before, and I understand the hardship presented with those types of cases. Those might make it almost impossible to comply with the zoning ordinance. But if you're looking at the application submitted by JAS-AM, all that's happened is design and some substantial site work and expending substantial resources. And I want to clarify, I think Lisa may have noted that the footings have been poured, but that's not correct. And I think David cleared that up. The footings have actually not been poured. Trenches for the footings have been dug. But again, no concrete's been poured. We're talking about digging dirt. And so there's some grading that has been done, admittedly, but that grading would have been done regardless of what the setback is. And the retaining wall that's been put up, and it's on your screens right now, that retaining wall would have had to have been put in regardless of where the setback is. Just to orient you, that retaining wall is on the opposite side of the property from the setback at issue. And so the work that JAS-AM is claiming that it already did, it's three things they've claimed: architectural design, a retaining wall, and some site work that includes grading and maybe digging some footing trenches. Those all would have had to have been done regardless. These are not negated by the change in the setback. Although, admittedly, the footing trenches may need to be filled in and redug. Again, we're not talking about removing concrete. We're talking about moving dirt. Getting into the legal standard and analysis, now that I've oriented you a little bit to the facts and the background, the standard here is not whether JAS-AM is proceeding in good faith. I know that David mentioned that, but that is really not the legal standard here. And even if it were, it's hard to say in good faith, if it's in good faith, if you've had access to the zoning requirements and you're a 30+ years experienced builder in the area, that you can look up in R4 zoning when you put R4 on your application yourself. And don't get me wrong, this is unfortunate that this happened. It is, but this does not mean a variance should be granted when you actually look at the legal standard and the 4 factors we consider. And that's what I really want to hammer home, is that confusion does not mean a rule or a law has to be changed. So looking at then the 4 factors that we look at under the analysis that's before the board today, unnecessary hardship, whether or not that would result from the strict application of the ordinance, absolutely not. We're looking at unnecessary hardship. It's a high standard, not just hardship. I'm not saying it's going to be easy to move that dirt around, but the grading and retaining walls are there, and having to fill in the trenches and redig them does not equate to an unnecessary hardship. I want to note a couple of interesting things that David brought up in his presentation, as well as the application for the variance request. The applicant continues to reference this expending substantial resources as a hardship. But as the board well knows, that cannot be the sole basis for hardship under North Carolina law. Again, we're only talking about 4 weeks max of work done on the site. Some site work was done, but that site work, except for those trenches, would have had to have been done already. Also, the $123,000 figure cited by David, Mr. Murray, wasn't just spent on this mistake of the setback. He quotes 3 things that go into that $123,000: design, retaining wall, and grading. Well, Exhibit 9 that David just put up shows that the retaining wall has nothing to do with the setback measurement. Exhibit 10 that David showed is the grading picture. Again, it would have been done regardless. The footings have not been poured. The footing trenches can easily be refilled and redug. They do not equate to an unnecessary hardship. David cited 2 cases, which I found interesting because I read through them, and they actually stand for the exact opposite point he's making. The city of Raleigh v. Fisher is a 1950 case, nothing to do with the request for a variance. And it actually works against JAS-AM, even if you look at the argument in there. The issue in that case was whether amendments to a zoning ordinance would apply to a specific property. The party in that case claimed that it had been conducting commercial business at a property for years, even though it was zoned residential. So there was a zoning violation. The court in that case looked at whether the city, even though it had, quote, encouraged and permitted the party to violate the ordinance for 10 years, whether the city was prohibited from enforcing the zoning ordinance because it had encouraged and permitted the person to run a commercial business. And the court said, no, yeah, the city can absolutely enforce the ordinance, even though the officials had encouraged violations of the ordinance in the past. And so the citation that Mr. Murray uses doesn't actually stand for what it seems to. What the court said, if you take all of the citation, is nevertheless, the law must be so written, for a contrary decision would require acceptance of the paradoxical proposition that a citizen can acquire immunity to the law of his country by habitually violating such law with the consent of public officials. And so it works against JASM, and I know that's a lot of legalese, but what that's saying is that even though a public official or a city member had encouraged or consented the zoning violation, the city still should enforce the zoning violation. And so even though that case notes there is hardship, it does not say it's unnecessary hardship. It does not deal with a variance request, and it still says the city should go after the zoning violation. The Helms versus City of Charlotte, also cited by David, is a 1961 case. Again, doesn't deal with a variance request. And here the court found that a City of Charlotte employee mistakenly issued to plaintiff a permit to install subterranean oil tanks. But even so, the city should still enforce the ordinance. So if anything, those two cases actually ask the board and suggest to the board that even though the city or the permit may have been issued through a mistake of the city itself, the ordinance should still be applied. So those two cases actually work for us. And there's a case called Showcase Realty and Construction Company versus the City of Fayetteville Board of Adjustment. That is a 2002 case, so we're talking much more recent, and it's a Board of Adjustment case. In that case, a man named Burnham was the applicant for a variance. He submitted a site plan to the city, which had a front setback of 50 feet and a side setback of 30 feet, which is what was required. The site plan was approved, construction began, concrete slabs were poured in that situation. And during construction, the city found that the setbacks were actually in the as-built was less than what was required. The city or the court cited various cases and noted that an unnecessary hardship occurs, quote, where the restriction, when applied to the property in the setting of its environment, is so unreasonable as to constitute an arbitrary and capricious interference with the basic right of private ownership. Again, a really high standard. The court also noted in that case that financial loss alone is insufficient to constitute an exceptional hardship to justify a zoning hardship. So in Showcase, the court found no unnecessary hardship and stated that a variance should not have been granted. Again, that was a much more further along. There were concrete slabs poured in that case, and you were looking at financial loss for the most part. So the reason I say that Showcase Realty should apply is that in this case, there's not as much hardship to show. And still, even with more hardship in that case, unnecessary hardship was not found and the variance should not have been granted. So in this case, again, we're arguing against unnecessary hardship in light of the case law, but also in light of the fact that the items cited by JAS-AM don't constitute unnecessary hardship. Architectural design was already going to be done. It may have to be edited, but as we all know, projects and architectural plans get revised all the time. The retaining wall would have had to have been put up. The grading would have had to have occurred regardless. And again, the foundation or the footing trenches can easily be filled in and redug. Expending substantial resources is insufficient for unnecessary hardship. So that's the first prong. The second prong, again, whether or not the hardship results from conditions that are peculiar to the property. No, There's no question that the hardship does not result from conditions of this property. There is nothing about this lot that requires the hardship. All that happened was JAS-AM put an R4 zoning note on its permit application. It was mistakenly granted, or it was granted, but mistakenly noted the 15-foot, and they proceeded, even though they could have looked up the law themselves when they knew, or the zoning ordinance, when they knew there was an R4 designation. So the hardship results from a bad design that wasn't in compliance with the zoning ordinance. The design itself was wrong and an error, and that's a personal circumstance that is on JAS-AM and its design team for designing something that had a 15-foot setback that it knew was an R4 designation. So again, that's a personal circumstance which cannot be found under this prong, and it's not peculiar to the property. There is nothing about the location, size, or topography of this lot that creates the hardship here. I noted in the document that went out today with the kind of tentative rulings, that one thing the board says is the hardship is unique to the subject property since the property located across Towns Road is undevelopable. Therefore, the property which would be most impacted will not be developed. And I'm having a hard time trying to figure out how that makes this how that makes the hardship peculiar to this subject property. Again, the hardship being the setback requirements. There's nothing on this property that makes that setback requirement not able to be met. Again, it's just a mistake. The hardship did not result from actions taken by the applicant or property owner is another prong for this board to consider. That's exactly what we have here. Again, the applicant owner is the one who messed up in designing and developing a property that wasn't abiding by the zoning requirements. We've got an experienced developer here. He knows where to find the zoning requirements. And JAS-AM purchased the property with notice of the setback requirements in the zone. If it was going to buy or build a duplex on this property, it had constructive notice because it could go and look at the R4 zoning requirements. Finally, the spirit, purpose, and the intent of the zoning ordinance for public safety and substantial justice. The fourth prong weighs in favor of opposing the variance request. The zoning ordinance aims for safety and justice. And in looking through some of the pictures that are up on your screen, if y'all wouldn't mind moving forward, there are, thank you. You can start to see, yeah, this is a great stopping point. The corner of this property, if the building or the duplex is allowed to go an additional 15 feet toward the curb, it kind of blocks this turn, right? And so there are safety issues that would exist if the setback were allowed to stand at 15 feet. We're trying to prevent any obstruction of the view. Again, I won't go back into details, but the 2040 comprehensive plan citation, the comp plan focuses on equitable housing and more affordable and diverse options. We're going to be dealing with some luxury duplexes that are going to go for a good bit of money. Granting the variance starts a pattern or a trend of allowing duplexes on all lots and allowing them to abut the street. This is a residential neighborhood, a really affluent neighborhood that it's trying to maintain its neighborly feel. It's already hard to do that in these types of neighborhoods in Charlotte because of the inundation of development, where every single lot is an opportunity to developers like JAS-AM to make money. We're trying to push back as much as we can on that here today. We're trying to stop the overdevelopment of Charlotte and curtail developers kind of the seeming autonomy and authority to do as they please. So we're just asking the board to uphold the law and the zoning ordinance and agree that this standard has not been satisfied. You know, if we have to take it to court to make sure the right decision is made, you know, we'd have to. We're hoping that that's not going to be what happens. We're hoping that JAS-AM can just quickly make some edits to its design, since nothing really has been done on that property to start the actual construction. And we're asking the Board of Adjustment to consider this opposition and to deny the variance request. I'm happy to answer any questions that any of you has. Thank you.
Thank you, Mrs. Litwack. Are any of your clients on the line? If they would like to speak, if so, of course, I would have to swear them in. I just want to make sure before I ask the board if they have any questions for you.
Sure. If any of them want to speak, I'm not sure if Mr. Edwards has made them a panelist yet to where they can ask to speak. I see maybe I see some hands being raised under the attendee list. So it looks like Amy Height, who is one of my clients, as well as Greg, would like to speak.
Okay, great. Terry, just let me know when Mrs. Hyatt is up on the panel and I could swear her in. Okay. Okay, I think I just saw her come up. Good morning, Mrs. Haight. Can you hear me?
Yes, I can hear you. Can you hear me?
Yes, I can. Just a slight echo on your end, but I think that we should be okay. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes.
Okay, thank you. All right, you may proceed.
Hold on 1 minute. I'm going to get rid of the echo.
Sure thing.
Okay. Is there an echo now?
No, it's better.
Okay. So thank you, Nancy, for your input. That was very informative, and we support your effort here. We're a close-knit neighborhood, proud of our homes and the security of the area. We want to maintain the unity of design and respect zoning laws already in place. Changing the setbacks will forever change the integrity of the neighborhood. Jazz Am should have been aware of these codes, as Nancy has well pointed out, especially given their history of building for 30 years. So I support our opposition to this variance.
Okay, thank you, Mrs. Haight. Do you have anything to add? Or I just want to make sure that I'm
No, that's
not
it.
moving on. Okay, thank you very much. Terry, is there anybody else wishing
Mr.
to
Chair,
speak?
just real fast, can
yes,
I have
yes,
Mr.
Mr.
Height, Mrs. Height's address? I don't have addresses from anybody. Typically, when they speak, they say their address. Thank you.
1419.
My apologies. Yes.
My address?
Yes, please.
And
we're at 1419 Towns.
Jason.
We're right next door.
Okay, thank you. All right, Terry, is there anybody else wishing to speak in opposition?
Next in line is going to be Larry Lippy.
Okay. Okay. Mr. Lippy, can you hear me? I see that you are on. Ms. Lippy, if you can hear me, just so I can be consistent here, can you state your name and your address, and then I will swear you in. His line is unmuted. Okay. Terry, is this line unmuted? I see on my screen he has his hand up. Doesn't look like his line is muted.
It's unmuted and he's a panelist, so there may
Okay.
be a hang up on his end.
Yeah. Miss Lippy, can you hear us? If not, Ms. Litwack, what I can do, I can go to your next client and then come back to Mr. Lippy. Just for the sake of time.
Thanks, Mr. Wilson. And just to clarify, Mr. Lippy is not my client. So just in case that matters. But I do see that Greg has his hand raised, and he may want to talk as well. And he is one of my clients.
Okay. All right. Can you hear me?
Next in line, we'll go with Keys Niemeyer.
Okay. All right, Mr. Niemeyer, can you hear me?
I can't hear you. Can you see me and hear me?
Yes, I can. Yes.
Okay. Good morning.
Good morning to you. Can you give us your full name and your address?
Yes. Keys Niemer, 3156 Willow Oak Road, about 4 or 5 houses up from the property in discussion this morning.
Okay. All right. I will have to swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes.
All right. Great. Thank you. You may proceed.
Okay. Thank you, Mr. Chairman, and everyone for your chance to speak this morning. I am not represented by Mrs. Litwack, but I do agree with the majority or with everything that she said. Just a couple quick comments. First of all, I disagree fully that the hardship is the applicant's fault. As Ms. Litwack has said, and as the builder has said, they've built houses in Charlotte for 30 plus years. They've built duplexes. They absolutely should know how to look up the zoning codes and understand the requirements. The fact that they put the wrong setback on the application is really irrelevant. It's too bad that that error was made, and it's also too bad that the city inadvertently approved that. But the code requires that a 30-foot setback be placed on both Willow Oak and Towns. The neighborhood, as Mrs. Height said, we're very close in the neighborhood. We're trying to maintain the aesthetics and the feel of the neighborhood. This would be the first duplex on the street. Not in favor of that, but that's really irrelevant. Also, the fact is that the property and the design that's been placed is not in compliance with the code, and that's the bottom line. The builder should have followed the code initially. They should have looked it up. 2 errors on the property doesn't mean that we should make a 3rd error by allowing the variance to proceed. That's just 3 errors, and 3 errors does not make this right. So as Mr. Murray discussed, and Mrs. Litwack, really do not believe that the application for the variance meets all the 4 criteria. I disagree that the standard's been met. And I'm in commercial construction and engineering myself. I've gone through built many projects where mistakes have been made, and we had to go spend our money to go fix the situation. And as Mrs. Litwack says, really only 2 of the 3 items would have had to been incurred no matter what by Jazz AM. So the amount of money spent for a commercial luxury home builder is really very small, and it does not represent a hardship, in my opinion. And I would ask that the zoning request please be not be accepted for the appeal, or the variance not be accepted. Thank you.
Thank you very much, Mr. Niemer. Just want to make sure I pronounce your last name.
That was correct. Thank you.
Thank you very much. Okay, Terry, who do we have next? I don't know if Mr. Lippy's line is unmuted, but who do we have next in line to speak?
Next in line will be Greg Zage.
Okay, and Mr. Zage is speaking in opposition, correct?
That is correct. Mr. Zage is in opposition.
Okay, Mr. Zage, can you hear me? Okay, Mr. Zage, are you there? Terry, I see that his line is open, but I'm not sure if he's a. Oh yeah, it does show he's a panelist, but
Yeah, he is a panelist and unmuted at this time.
okay. Okay, Mr. Zage. All right, so I think we can come back to him. Who else do we have?
That's all I have signed up for opposition right now. Everyone else is in attendance.
Okay, all right, thank you very much. Board members, do you have any questions for Mrs. Litwack? Okay. All right, if there are no questions from the board for Mrs. Litwack's presentation, that should conclude our presentations right now, and then we will have to move into
Mr. Chair,
deliberation. Yes, sir.
The applicant has rebuttal.
Okay,
Yes.
I was going to ask that. Mrs. Sanchez Myers, is that correct? Applicant does have the rebuttal, correct?
Yes, I was just gonna say
Okay.
that to give staff and the applicant the opportunity to respond to anything.
Got you. My apologies, Mr. Murray. You may proceed.
Thank you. Mr. Niemer, I was just looking on GIS. I just did a measure. I was looking for the location of your house. Is it fair to say it's approximately 400 feet from this property?
We're about four or five houses away.
Okay. On the other side of Willow Oak North?
Correct. On the other side, yes.
Okay, so. Okay, thank you. Members of the board, Mr. Bowers is on, and he was just going to talk a bit in rebuttal about the differences in what they would have done on this site had it been a 30-foot for the front unit as opposed to what they built in compliance with. And so I think he's on. Brand, are you there?
Yes.
Okay,
So,
if you can talk a little bit about the differences.
Going back to when we were in due diligence, we actually contacted the city about this because as a builder, even though we are always working with code books and things like that, we always talk to city and county staff about how they're going to enforce things so that we have full understanding because we feel like that's where the rubber meets the road. It's what is the city and the county, how are they going to view it? It's just like building standards. They have interpretations of code. So sometimes they enforce code more strictly than what the code book says. And in this case, we always we always talk to the city. We're very careful about it. We obviously have a very big investment in the land. And before we set out onto a 9-month design timeline, we want to understand what our design guidelines are. So we got those guidelines before the design was done. And then as we proceeded into permitting, they actually issued 2 permits. Each duplex was permitted. So they issued the permits twice with the same information that we submitted with the incorrect setback for each unit being approved. So, we always trust in our city and county officials because who should know more about those items than them? That's what we feel like. We're not experts in zoning. We go to the zoning officials and ask them. So, and there's always a lot of, there's things that change about open space and these things. So we just always want to refresh ourselves as we do these projects. We don't do a lot of duplexes. We've done 2 in our history. So we are primarily a single family home builder, and we've recently done a couple of duplexes as the move for people to move closer to the city has been more popular. And going back to that is once that design is in place, it's a system. So the position of those units relative to the existing topography defines what kind of retaining wall we need. It defines how big it is. It defines, the grading guidelines for that site. So knowing all that, we might have done this entirely differently had we known. We might have gone a different approach and tried to, completely configure these units in a different manner in order to maximize our investment and also to, make the project as aesthetically pleasing as possible. So that's really, it's a system. So when you change one thing, you're changing it all. And The wall is part of that system. The other thing about the footings being excavated is that now that we've unearthed the original grade there, as we move things around, we could be trying to put structure on top of something that is now it's loose fill because we've already excavated it. So the best way to build this is to do it once the right way and not move things around so that you're then trying to build a new structure on unsettled dirt that you inadvertently excavated yourself based on this permitted project. And I also want to point out on the safety issue that the attorney brought up is you realize that if we were building a single family home facing Willow Oak, we would be able to build 15 feet from Towns Road all the way down Towns along our building footprint. So the sightline restriction could actually be worse had we chosen to go the single family route. So I don't feel like that is a very valid argument at all. In fact, it's weak because we could end up making the sightline worse with a single family home. So
Thank you. Members of the board, I also want to point out a couple of things here. When we're looking at, and then I'll talk about the case law, but when we're looking at the variance standards, once the city or the applicant makes a showing on each of the 4 elements of the variance, which has occurred here, then it's on the opposition to present substantial competent evidence that would overwhelm the showing that's been made by the applicant. And the testimony from the neighbors has just been general testimony. There's no evidentiary basis in the testimony, and the statements by Ms. Litwack have been primarily legal argument. And so at this point, there hasn't really been any substantial competent evidence presented against this variance. I'll talk about, fortunately, I've dealt with the showcase case, and the case that Ms. Litwack didn't raise is called the Turek case. And these cases have come up. I actually had a case in Superior Court where the town of Huntersville Board of Adjustment denied 3 variances when a builder had built in good faith reliance upon 3 permits that had been issued. And the Turek case talks about the showcase case, and it explains why the showcase case came out the way that it did. And what the Court of Appeals says in Turek is, here's what we have here. We have a validly issued permit where the evidence is that the property owner proceeded, had no reason to believe there was an issue, and proceeded in good faith reliance upon this permit, built outside of compliance, and they upheld the variance. In the showcase case, they point out that there was testimony, competent evidence testimony, that because of the way that the property had been built, that it caused damage to adjacent properties, that it caused safety issues because of the setback. And on top of that, in the showcase case, prior to construction, there were genuine questions about where the actual setback was. There were legitimate concerns that there was a problem with establishing where the setback was from the beginning. And so that's why I talk about this good faith as part of the beginning part of my presentation, because that's really where this turns. You had the variance, I think it was a year ago or so, where the pool house, this board denied a variance for a pool house. And the evidence had been that the property owner had never gone to the zoning department to find out what the setback was. He'd only gone to an attorney who gave him a bad interpretation. And as a result of that, this board said, well, you had reason to believe that there was a problem here. You continued to build even after the neighbors objected. And now you're seeking a variance after you had continued to build this structure And it just didn't appear to be in good faith, even though there was a permit. In this situation, you have the opposite. They've done everything in reliance. They went to the city to confirm this. They had built only on R8 that does not have any of these side yard standards. And they obtained a permit, and as Brent just said, not one, but 2 permits. And the only time that this came up was not because a neighbor complained or there was an issue. It was because Brent went to the permitting department to confirm his permit for the detached garage. And that's when this came up. That's when the issue had happened. But they had already started construction on grading for that front unit. And so that's what's important to point out here about the difference in the showcase decision and the Turek decision is really turns on good faith versus bad faith. Whether you thought that there was a problem and you ignored it, you proceeded, or whether you built in compliance to what was issued to you, what was legally issued to you. And in the situation here, that's where this turns. There is not a safety issue. As Brent pointed out, this slide is sitting here on issue 5. If they were building single family, as Brent said, they would be closer to this street. And so there is no safety issue. And so if there's not a safety issue, then ultimately what it comes back to is the board balancing the interest here. So the board has to say, okay, we have a 15-foot side yard that's in a permit, but the zoning ordinance says 30 feet. We agree that the zoning ordinance says 30 feet. We understand that it says 30 feet. And Ms. Litwack, I don't think she was saying this, but just to be clear, we're not arguing that the city can't enforce the zoning ordinance. That's why we're seeking a variance. We're seeking a variance to try to fix what had occurred, to make it right. We're not seeking a variance because we're trying to amend the ordinance. That's not what's going on. We acknowledge if we thought that the city was wrong in interpreting the ordinance, we would file an appeal. We have not appealed what the city said because we agree that it's 30 feet. We're seeking a variance because we've made these changes to the site. This is the only site in this location that has this issue. In the Turek case, it was a property line issue, and they said it was unique to this property because the circumstances that occurred in the Turek case were specific only to that case. It's the only, that property. It was the only property in the area where the exact circumstances had happened to that property. That was what they said was the peculiar requirement, that it's peculiar to this lot. And here, what has occurred on this property is peculiar to this lot. The hardship would not have occurred without the city granting the permit. And so it is this board, we come to this board in order to fix that problem, for this board to grant a variance based upon a hardship, based upon there's a peculiar situation on this property, based upon the fact that we didn't cause it, we operate in good faith, and then balancing the interests of enforcing a 15-foot setback, a 30-foot setback versus granting a variance for a 15-foot setback. And when you look at all those standards, when you listen to what's been argued against without any substantial competent evidence against, the board must grant this variance. And so we're happy to answer any other questions, but we appreciate the board's time and consideration and ask that the board please grant this variance. Thank you.
Thank you, Mr. Murray. Mrs. Litwack, do you want to respond to anything that Mr. Murray said in his rebuttal?
Thank you. Just a quick reply. I still have not heard anything regarding how the retaining wall grading and how the designs create the substantial hardship that has to be met. Mr. Murray's asking me to provide evidence in contradiction to that. I can't look at JASAM's financial records, and I don't have access to those. Maybe if we go to court, I can ask for some discovery about that. But what I'm saying is that this stuff, again, no one has said, you're right, we only did that in relation to the actual setback issue. And so other than some cost being expended in digging those foundation trenches, there's no substantial hardship. As to the other two prongs, I would just reiterate that this is not peculiar to the property. Again, looking at the language of the standard, the location, size, or topography of the property has not created this hardship. It is not at all that. It's resulting from personal circumstances in the design, of creating a 15-foot setback in the architectural design that JASAM submitted to the city, as well as the personal circumstance of not verifying the zoning ordinance as a sophisticated builder and knowing that it was an R4, which is why they put the R4 on their permit application. So again, I think that hits the personal circumstances in the second prong, as well as the hardship resulting from actions taken by the applicant. And that's all I have to say at this point. I understand. We trust the board to rule on it as it will. Thank you.
Thank you, Mrs. Litwack. Mr. Murray, do you have anything to respond to Mrs. Litwack, if any, briefly?
Sure, just briefly. I don't want to keep this going back and forth, but Mr. Bowers testified about the topography, about the grading, that once you change the location of the grading, the soil's not set, it's different, it changes the way the site's developed. Topography is definitely an issue at play here. Thank the board.
Thank you very much, Mr. Murray. To the city staff, do you have anything to add further to this?
I have nothing further to add.
Okay. All right, great. Okay. Ms. Sanchez Myers, I know we had some neighbors who were trying to speak but did not. Do we have to allow them to speak, or can the board go into deliberations at this time?
So since the evidentiary hearing is still open and hasn't closed for deliberations, I would just recommend checking with if there were other speakers.
Yeah.
That
Okay.
may have been having technical difficulty just because of this remote platform. We want to make sure that everyone who had signed up has the opportunity to speak, and then hopefully we can move on.
Okay, great. Great. And Terry, I saw in your chat that we did, your chat directly to me, that we had a Gabe Gerber who would like to speak in opposition. And I don't know if Mr. Gerber is on, and I know that we also had Mr. Lippy that had some problems coming in, and I believe Mr. Zaid as well.
That is correct. We'll start with Gabe Gerber, then we'll go to Lippy, then we'll go to Zage.
Okay. Mr. Gerber, are you there? Can you hear me?
Hold on just a second. I will go get him.
Okay.
This is Gabe Gerber, 1433 Towns.
Good morning, Mr. Gerber, and thank you for giving us your address. I just have to swear you in.
Sure.
Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay, great. And just for the record, can you just please give us your full name and address again?
It's Gabriel Brian Gerber. It's 1433 Towns Road.
Okay, thank you very much. You may proceed.
The only feedback I wanted to provide was that we live in a neighborhood that is really under pressure from development, and have hope that zoning ordinances and zoning laws will be upheld, and know that this is our only opportunity to go ahead and say that we're in opposition of it and would like to keep the character of the neighborhood as close as we can to what it is within respect to development, and that citizens have a voice and do that through this type of medium, and would like to say that I oppose it.
Okay, thank you very much, Mr. Gerber. And I believe Mr. Lippy is next, Terry, am I correct?
That is correct.
Okay. All right, Mr. Lippy, are you there?
Can you hear me?
Yes, I can. Good morning to you.
My name is Larry Lippy. I live at 1419 Towns Road, and and I'm adjacent to the property in question. My comment.
Okay, great. One second, Mr. I have to swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay, and then for the record, could you please give us your full name and address again?
It's Larry Lippy, 1419 Towns Road. I am the
Okay, thank you very much.
directly adjacent to the property in question.
Okay, great. You may proceed.
Well, the question that seemed to have been passed over or glossed over rather quickly was the safety issue. When that property was purchased, there was a ranch that faced Willow Oak, and the side yard actually faced Towns Road, which would allowed it to have a 15-foot variance on the Towns Road side since it was a side yard. But now that it's become the front of a second unit in that development, we feel like it's going to be a real safety issue. And here's why. As the neighborhood becomes developed, we have lots of small ranches that are being, torn down and building much larger houses, and that's fine. We're trying to keep the integrity of the neighborhood. And as new people move in, lots of them have kids that ride bicycles up and down our cul-de-sac, it's not a cross-through street. I mean, there's no access out of the cul-de-sac except through the Willow Oak entrance. And as children ride their bikes up to the corner, if there's a unit that is only 15 feet from that corner, which is a four-way stop, by the way, and I've seen many cars and bicycles on Willow Oak just blow those stop signs and just fly through. And if you can't have total access to that street, it could be a very dangerous situation. So my point is, and just recently we had a festival in the park in which both sides of Willow Oak and Towns Road, even our little cul-de-sac, gets inundated with parked cars, which then increases the lack of visibility as you come to that corner. So my point would just be, again, watching out for the kids and keeping our neighborhoods safe. And that to me is critical. And I thank you for your time.
Thank you very much, Mr. Lippy. And then Terry, who do we have next? I'm sorry, who was the last name that we had?
Mr. Chairman, just for the record, since this is quasi-judicial, I do have to put my objections on the record to speculation on the last testimony on safety and whether that's material. So those are my objections to that last testimony. Thank you.
Thank you very much. Okay. Terry, who do we have next?
Greg Zage.
That's right.
Yes, I'm here.
Okay. Mr. Zage, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes, I do.
Okay. Could you please, for the record, give us your full name and address?
Sure. It's Gregory Mark Zage, and the address is 1441 Towns.
Okay. All right. You may proceed.
Okay. Thank you. And first of all, I wanted to thank the zoning board for taking the time to hear from some concerned neighbors in the neighborhood. Personally, I actually support development, but prefer it to be smart and sensible development that we would view as an overall improvement for the community. Primary concern here really is safety. And then to Mr. Murray's point, this is my opinion, of course, but I do appreciate Larry's comments about children in the neighborhood on this cul-de-sac around those turns, because those children are my children. Anyone who has taken their children through this neighborhood and through this particular stretch of the neighborhood will be able to attest that it is already a difficult corner. Sight lines are already challenged. Both the developer and Ms. Litwack, who, by the way, does not represent me, cited topography of this particular lot. I pulled up on Polaris. It looks like there's about a 12-foot elevation gain over about 75 to 80 feet, turning right off of Towns onto Willow Oak. Our concern with a 15-foot setback as a side lot and then presumably shrubbery, landscaping, what have you, is that it would further impede the ability of pedestrians, notably children and families, though of course elderly residents as well, to be able to see around that corner, and the other side of that coin, allowing drivers to be able to see the pedestrians. I'm not really here to speak on whether the setback should be approved or not, but if it is approved, if the variance is approved, we would strongly urge the city to require the developer to put a sidewalk in along Willow Oak at this corner here, preferably downtowns a little bit. Yeah, I would view that personally as an improvement for the neighborhood. I think the developer could acknowledge that that would largely be seen as a value-added feature for the neighborhood. I would beseech that you use a 2-foot, the sidewalk zoning that requires a 2-foot setback with some grass, so that there is some space between the street as well and the sidewalk, so that children and families can feel a little safer. Really no rush in putting this in. This can be done anytime over the next couple of months to quarters. And frankly, it's a rather cheap expense. We're not talking about a ton of concrete here. It's
Mr. Zage, your line started to break up. I don't know if you were at the end of your comments. Just want to make sure that I don't cut you off.
I'm sorry, but I can't hear anything you're saying.
Yeah, Mr. Zage, we aren't able to hear you. Your phone is breaking up pretty bad, so unfortunately we will have to stop right there. But we did get the bulk of what you stated. Okay. All right.
Mr. Chair, just again, like last time, Mr. Zage foreshadowed to this, but I have to object on speculation and materiality here. Again, single-family residential house can be 15 feet from the side yard here. Thank you.
Noted. Noted. Right, Terry, I believe that was all of the folks we had signed up to speak in opposition. Am I correct?
That is correct, Chair.
Okay, great. Board members, before I go to the board, just want to say that this closes
Mr. Chair, I have a couple questions for staff that I'd like to ask.
Sure thing, Mr. Floyd.
Lisa, can you pull up the photo or the exhibit that has kind of called the to be built plan, assuming the variance is granted?
One moment.
All right. Thank you. So, Lisa, my question for you is, I mean, I've heard Mr. Murray say it, and I've heard, I believe Mr. Bowers stated that if this were a single family residence built facing Willow Oak Road, that essentially you would have a 15-foot side yard down Towns Road. Is that correct?
That's correct.
And so as the proposed construction, you will have a 30-foot setback on Willow Road and then a 15-foot side yard for the Willow Oak Road facing structure, and then a 30-foot setback for the Towns Road facing structure. Do I understand that correctly?
That is correct.
Thank you. That's all I have.
Thank you, Mr. Floyd. Are there any other board members that have any questions?
I do have one question. My understanding was that the notice of violation was issued on July 28th. I believe it was Mr. Murray stated that it was found when they applied or were checking on a permit for a detached garage. How did this all come about? I guess if someone could clarify that point.
The code enforcement records indicate that it was a field observation by the code enforcement officer, but it sounds like there might have been some more communication outside of that with the permitting staff.
Thank you.
Yeah, this is Shad Spencer. Just to add to that, when the applicant applied for a permit to build a detached garage, the reviewer caught the fact that the duplex was approved in error. So at that time, the folks who handle the permitting then contacted the code enforcement and then also contacted the applicant to make them aware of what was going on, that there was an error, and that in order, we have to do the enforcement. So we had to send an NOV, a notice of violation, to the applicant.
Thank you.
Are there any other board members that have questions?
This is Marshall Williamson. I had a question on whether or not it would be possible for the developer to subdivide this lot and do 2 single-family homes on that, on 2 separate lots.
Based on the acreage, it looks like it's slightly over half an acre. So it would be possible to subdivide this into 2 single-family lots. Because it's R4, which then has a base density of 4 dwelling units per acre. So with half an acre, you could have 2 single-family lots.
And what would those setbacks be on Towns Road if they were to? I was looking at the houses on Willow Manor to the south, and it seems like they have maybe a smaller front yard setback, larger rear yards, but I'm just trying to figure out if
So
they
what
could. Go ahead.
Yeah, I'm sorry. It looks like they would end up, subdividing, splitting along the town's road, those sides. So it looks like it's 100-foot wide now. I mean, 200 feet wide now. So each lot would be approximately 100 feet wide and just split it right down the middle. So both of those homes would front technically along Towns Road. So those would be a 30-foot setback. And then the setback along Willow Oak, since that would then be a corner lot, would be 15 feet.
And what would be the rear yard setback if they fronted on Towns?
The R4 has a 40-foot rear yard requirement.
Mr. Williamson, do you have any other questions?
Not at this time.
Are there any other board members that have any questions, any other questions? Okay. Hearing none, I believe this will end our presentation and testimony. But before we move into deliberations, I just want to ask the board if you need a 5 to 10 minute break or what have you before we go into deliberations, or do you just want to just dive right into it right now?
We can dive into right now so that.
Agreed. Maybe we take a break after.
Yeah.
Okay. All right. Great. Okay. Now we are moving into deliberation. Just a reminder to those who have presented in opposition and in favor of this case, are not allowed to ask any questions or make any presentations, what have you, during deliberation. So now we are in the deliberation period. Board members, what are your thoughts on this case? I guess if you want to speak freely, you can, or if not, I can just go one by one. I know we've done that in the past, but just want to make sure that just kind of check everybody's temperature here on how they want to proceed. But you know, I guess Mr. Floyd, I'll come to you first to get your because you you know, asked a couple of questions during the presentation just to kind of see what do you think?
Yeah, sure. I think I'm inclined to grant this variance. I always kind of do the same analysis that I think Mr. Murray does every time he's before this board, which is to walk through the 4 factors and see whether or not I think those evidence has been presented to demonstrate those. Unnecessary hardship. I think we heard evidence that, you know, essentially construction has already begun with digging of the footers. I do understand, you know, the difficulty that would be created if you have to fill those back in and then move the location of the building and kind of, you know, what that does to the soil and things for a structure. I think, you know, here, I did ask the question about whether or not the developer had experience in dealing with lots that are zoned this way. Given that they have not, you know, and given that the permit was actually issued allowing the 15-foot setback, I do think that's a hardship that results from some action outside of the developer. I mean, they relied upon a permit that was validly issued in moving forward with their construction. That to me is something that's peculiar to this property. It is, you know, there's not other properties where you've got invalid or incorrect permits issued. And then when you go to the 4th factor about the spirit and purpose of the zoning ordinance, I think this is consistent. I mean, I hear the homeowners talking about, you know, safety issues and things like that, but as kind of the last questions I asked, I mean, if you put a single family residence on this property, it could be located exactly where that Willow Oak Road facing unit is. And so really what, you know, and they're agreeing to move back the Towns Road unit, aren't seeking a variance for that. So to me, there's not any difference between what is occurring here with the variance and what you would see with a single family residence constructed in this same location. So I appreciate this, the homeowner, the neighboring property owner's concerns, but it's not like we're being asked to grant something here that is really outside what would, you know, otherwise be permitted under the terms of the ordinance. And so given those things, I'm inclined to vote to grant the variance.
Okay, thanks a lot, Mr. Floyd. Mr. Williamson.
I'm sort of in favor of what John said, just because the alternatives to do what's available by right is almost worse than what, you know, worse for what the neighbors are seeking. If they were to subdivide it, it's going to be more compacted on that site with 2 homes. If they were to do one large home, it's going to be right in those setbacks as well. My only fear is that there's a contractor that's purchased the lot right across the street that, you know, I'd asked zoning folks to make sure they pay special attention to whatever that gentleman comes up with when he applies for a permit, just to make sure he's, you know, being genuine with what he wants to do on that site. But as far as this one's concerned, I think by right is much worse than what they're proposing.
All right, Ms. Long.
I would agree with both board members that already spoke. I think, the fact that it's a duplex is irrelevant to the conversation because it is allowed. And it is unfortunate the city inadvertently made a mistake. I do believe that Jazam should have researched more thoroughly to understand the setback requirement, but I am inclined to approve the variance.
Okay. And Mr. Ragu.
Yeah, I do agree with the three of the colleagues what they said. Again, it's a mistake done by the city and by approving it, but unfortunately, we should not provide hardship to these guys. But I have one quick question. So the safety issue on the corner, is there a way that we can avoid that by adding something? I don't know. There are requesting builders to do something there.
Okay. Shad or Lisa? I don't know if you heard Mr. Ragu's question.
Mr. Chair, I think if we were to get input from Shad or Lisa, we'd need to go back
Yes,
into
you're right
general
about that,
session.
Mr. Floyd.
That might be
Yeah.
a question better suited to our legal counsel.
Yes. Yes.
But I'm in favor of approval. Just I want to make sure if there is anything that we can do there.
Okay. All right, great. Okay. As for me, just listening to the presentations and to the attorneys and to the neighbors, I know we've had cases like this that come up in the past. It's always been a hard decision. I'm more inclined to not grant it because just listening to Mrs. Litwack's presentation about the cases in the past and I think how the city had to go ahead and go with the ordinance. That is playing into my decision as well. But and I understand that the city did make a mistake here. But and I do hear what the board members are saying. I guess that's just inclined to possibly not grant it, but yeah. So okay. With that said, that ends our deliberations. We will move into voting. Is there a motion to approve or deny the variance?
John Floyd, motion to approve the variance.
Crystal Long, second.
Okay, we have a motion moved by Mr. Floyd to approve the variance and a second by Ms. Long. Now we'll do a roll call vote. Ms. Long?
Long, yes.
Okay. Mr. Williamson?
Williamson, yes.
Okay. Mr. Floyd?
Floyd, yes.
Okay. Mr. Ragu?
Ragu, yes.
Okay. And Wilson, no. But it looks like the majority has it, if I'm correct, and it looks like the variance has been approved. Now we will move to the findings and fact of law. Mr. Floyd, I'm going to come to you on this. Do we need to make any changes here based upon, and I guess Mrs. Sanchez Myers, upon any of the testimony that was made? I don't think we do, but I know there was a lot said. I don't know if they have to make any changes anywhere.
I'm sorry, if you're asking me, I would need a minute to go back and look and review. This has been a really long hearing.
Yeah.
So if you don't mind.
Sorry. Yeah.
I do think we need to edit the language of paragraph 21.
Okay.
I think at least what Mr. Murray proposed, and I think that I could be wrong, but I think the basis upon which the board voted was that the unique hardship here is the fact that the permit was issued improperly. And that issuance of an improper building permit is what creates the hardship.
So do we say that?
Thoughts on that?
So I think like maybe we should say that, I don't know, the hardship was how we word that.
I would say something like the hardship is unique to the subject property since a building permit was issued for construction on the property that fails to comply with the terms or the requirements of the zoning ordinance. Something like that.
Okay. Yeah, I think that makes sense. Yeah.
And I would just suggest as well that if there were any other factors that went into, that any of the particular conclusions of law, for example, peculiar to the property, that those could be included. So if that, just because if that affected anyone else's conclusions during deliberations, the property across the street, then that could also be included, and you could add to the finding of fact, but that would be for the board, for y'all to decide. I'm just suggesting that maybe some of the other board members, maybe that was part of their consideration, if you want to.
That's fine.
Discuss that.
Yeah, I just think we need to add in something about the issuance of the permit, because I think there was testimony on that, and that certainly was part of my reasoning for finding that the hardship was unique to the property.
And so would that be number 24, or could we add that in any of the existing facts?
No, I think it would just be, again, editing 21 and just say the hardship is unique to the subject property since a building permit was issued for construction on the property that was inconsistent with the requirements of the ordinance, and the property located across the street is undevelopable to its lot width. It would,
Okay. All right, great. Okay. Any other changes that need to be made before we make a motion on this?
This is Williamson. Do we need to say something about the idea that the ability to develop a more imposing structure by right was taken into account? Because really that's the reason that I would grant this variance, is because if we didn't grant the variance, then the developer's going to build as much on that property as he can build. And so by right, he can do two things. He could build one single family unit facing Willow Oak and, eat up that whole 15 feet of setback all the way downtown, or he could subdivide the property and do 2 units and then actually have a much smaller 15-foot variance on Willow Oak, which is really going to impact the neighborhood more than what this proposed construction is going to impact it with. So do we need to put that in there as number 24?
My suggestion, if we were going to include some language like that, is to include it as part of number 22, where it talks about the proposed placement being consistent with the spirit and intent of the zoning ordinance. Because I think you can point out that in a single family, this is consistent with what could be constructed in a single family context, and is perhaps even less intrusive than the use that could be made utilizing a single family development.
Well said.
All right. So, Mr. Williamson and Mr. Floyd, you just want to repeat what you just said that we need to add to 22 for the court reporter? I don't know if we're adding anything there.
John, you said it, summed it up pretty well. Could you do it again?
Yeah, I would just say that as part of paragraph 22, which references the variance being consistent with the spirit and intent of the zoning ordinance, that part of the consideration there is that what could be done with the property through single family, that what is proposed is consistent with what could be done to the property using single family development, and is perhaps even less invasive.
Okay. Okay, great. Any other changes before we move to a motion? Okay. All right. Hearing none, is there a motion to approve the findings and facts of law with changes made to 21 and 22?
This is John Floyd. Motion to approve the findings of fact and conclusions of law subject to the revisions that we've discussed.
Okay. Motion has been moved by John. Is there, Mr. Floyd, is there a second?
Williamson, second.
Okay. Motion's been seconded. I move for the vote. Mr. Floyd?
Floyd, yes.
Okay. Mr. Williamson?
Williamson, yes.
Ms. Long?
Long, yes.
Mr. Ragu?
Raghu, yes.
Okay. Wilson, yes. Okay, that concludes that case. Now, I think we should take a quick break. Say what does the board need? Does the board need 5 minutes or 10 minutes? Or all right, I see Ms. Long saying 10. Okay, so we will come back. My watch says 11:35, so we'll come back at 11:45. We have a case and appeal after this, and of course our minutes and agenda. I mean, our minutes and thing from last month. So, all right, see you guys back in 10 minutes. Okay. Do we have everybody back?
Yes.
Okay, well, staff, are you back too?
Yes.
Yes.
Okay, great. Okay, we can go ahead and continue. Our next case on the agenda, excuse me, is case number 2021-092.
One moment.
Sure.
Just hit okay.
You have to unmute it.
Oh, let me take it. Yeah, I'll do it.
Our next case is a residential rear yard variance case. The applicant is requesting two variances, a 6-foot variance from the 30-foot rear yard for compliance of the principal structure, and a variance from the 25% encroachment allowance to allow a deck to encroach 53% into the required 30-foot rear yard. And I'll give you a minute to look at your findings.
Okay, Lisa, you may proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The property is zoned R3 single family. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The property was subdivided in 2003, and there was a required 30-foot rear yard shown on the subdivision plat for the property. The single-family home on the property was constructed in 2005. Exhibit number 6 are the variance requests. In 2021, when the applicants obtained a building permit for a deck in the rear yard, they discovered that the existing home encroaches 6 feet into the required 30-foot setback. The proposed deck encroaches 53% into the 30-foot rear yard. The applicant is asking for 2 variances. The first variance is for the existing encroachment of the rear yard of the home, and the second variance is for the proposed rear yard encroachment for the deck. Exhibit 7 is considerations. The code allows a deck to encroach into the rear yard up to 25%. In the lower right, you can see the difference in the 25% encroachment allowance for the existing 30-foot rear yard in blue versus the additional 4.5 foot of encroachment allowance that would be permitted if the first variance for a 24-foot rear yard is granted in green. So from the 30-foot rear yard that's existing, right now they would have a 7.5 foot encroachment from that. And then if the 24-foot rear yard variance were granted, that would allow the additional 4.5 feet. A 24-foot variance or 24-foot rear yard would permit a deck up to 18 feet in depth from the rear property line. The applicant's second variance request is for the deck to be located 14 feet from the rear property line, which is shown in red on the larger graphic to the left. The second variance would permit a deck that is 22 feet in depth, or 4 foot greater depth than what would be permitted if the first variance is approved. Exhibit number 8 is considerations, and this is for variance 1, the 6-foot variance from the 30-foot rear yard for the existing home encroachment. Staff supports variance 1. The hardship does not result from actions taken by the applicant. The 6-foot rear yard of the encroachment of the 2005 home is not a result of the applicant's actions because the home was permitted, and the applicant has provided a copy of the Mecklenburg County Certificate of Occupancy dated June 7, 2005. The property owner states they were not aware of the encroachment until 2021 after they obtained the permit for the deck. The requested variance will not detract from the character of the area because the rear encroachment is centered towards the middle of the property and would not significantly detract from the pattern of the neighborhood's residential backyard character. Also, the rear yard abuts common open space for the subdivision, separating the encroachment area from impacting other single-family homes. The granting of the variance for the permitted 2005 home ensures safety since the work was constructed and inspected to NC building codes through the permitting process. Exhibit 9 is further considerations, and these are considerations for the second variance request for a 53% encroachment into the 30-foot rear yard. Staff finds that the requested variance does not meet all the criteria within the zoning ordinance for granting a variance. The hardship would be self-created. The applicant's building contractor was issued a building permit for the proposed deck that indicated that the rear yard was 30 feet. The plot plan submitted with the building permit showed the wrong lot, which you can see on the lower right. The lot shown had permitted building area in the rear yard to construct a deck, but the subject lot does not have the permitted building area in the rear yard to construct a proposed deck. Staff believes the permit was issued due to the wrong plot plan shown on the application. There is no hardship resulting from a peculiarity of the property. The code permits decks to encroach 25% into the required rear yard. If variance 1 is granted, it will allow a deck to encroach 6 feet into the 24-foot rear yard and 18 feet from the rear property line. This permits 4.5 foot of additional encroachment, as we went through before, than is currently permitted for the required 30-foot rear yard. Granting variance 2 would permit the construction of a deck that is 22 feet in depth. The granting variance 1 will allow a deck that is 18 feet in depth, and that's just a difference of 4 feet. So unnecessary hardships do not result from strict application of the ordinance. The hardships are the result of the actions proposed by the applicant and the desired depth of the proposed deck. They could shorten the proposed deck 4 feet and come into compliance with the 25% encroachment if variance 1 is granted. The requested variance is out of character with neighboring properties, which do not appear to have deck encroachments and appear to observe the 30-foot rear yard in aerial photography. So that's the end of my presentation. This is just showing that the other homes in the area seem to observe the 30-foot rear yard. And here's a photo of the home. And that's the end of my presentation. Please let me know if you have any questions for me.
Thank you, Lisa. I do have one question. For the second variance that staff recommends a denial for, and unless I missed it, did staff give any recommendations to the applicant so they can come in compliance if they want that variance approved?
So by granting the first variance that the applicant has requested, it would already give the applicants an additional 4.5 feet of depth for the deck and would allow them an 18-foot depth that's shown in green on slide 7. So the applicant desires a 22-foot depth deck, and by shortening the depth deck 4 feet, they could come into compliance if variance 1 is granted.
Okay, thank you. Board members, do you have any questions for Lisa? Okay. All right, if not, Terry, do we have anybody signed up to speak in opposition of this case, for this case, or in favor of the case?
No one to speak in opposition, but in favor, Joseph, or Douglas Gentile, I'm sorry, Douglas Gentile in favor.
Okay. Okay. Mr. Gentile, good almost afternoon. Just looking at my watch, I'm sorry. I will, of course, have to swear you in.
Go ahead.
Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay, great. And just for the court reporter, can you please provide your full name and address?
Sure. My name is Douglas Gentile, and with my wife, Paula Gentile. We live at 9319 Hanlon Court in Charlotte. First of all, I really do want to thank you guys for taking the time to speak with us on this, and I want to thank the staff for all their help. They've been really invaluable in all of this. So I'm grateful for their work in this also.
All right. Thank you very much. You have anything else to add, or is it?
We do in relationship to the variance number 2. The issue with our backyard is we put in the topographical map for this area of our house. And if you look to the back of our house, there is a significant slope in the back corner of the deck. And from where the deck is going down, there's a significant slope that goes down and makes that part of the yard dangerous. And I've even fallen back there. There's such a steep slope there.
And the reason we wanted to go back to the 22 feet, this would do a couple of things. One is it would close off that which we believe is a dangerous part of that backyard because of that slope. And it would make that space usable. When you go back to the back of our yard, if we go to the 14-foot setback, then we will have closed off what we think is a dangerous portion of the yard, makes it usable, and in fact gives us the ability to be able to have some usable space in the backyard, which we typically couldn't. Now, the other piece of that is if you look behind our house, we have no abutting property owners behind us. Behind us, there is a 30-foot tree save, I believe, and there's a 60-foot Duke Power right of way, and then backs up to a neighborhood. So if you look from the back of our yard, we've included four pictures. The four pictures depict the slope that goes back to that corner of the yard. And if you're looking from our house, looking back, the four pictures show all the way across the back and indicate the depth of that slope, which is really of concern. And the fifth picture is a picture from the back side. It's from the neighborhood on the other side where you can't even see our house. So to go back an extra 4 feet would obviously cure what we believe is a dangerous situation. Also in the neighborhood, there are sections of our neighborhood as you go around it that there are some as low as a 6-foot setback on the neighborhood. So we really would request consideration of the 22-foot setback, variance number 2, simply because we would have the ability to close off a dangerous portion of our yard and make it usable. And Paula, do you have any thoughts?
I'm not sure that I can speak because you haven't sworn me in yet. Is that correct?
Yes, that's correct. I would have to swear you in.
Okay.
Okay.
Yeah, if you could do that, that'd be great.
I just have one thing to say.
Yeah. Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay. And state your name.
Paula Gentile, 9319 Hanlon Court.
Okay. Thank you.
You mentioned, or maybe Lisa did, that all the other yards, or it appeared that all the other yards were within the 30-foot setback. The one thing you need to know in this particular lot is that we are the smallest. We are a ranch. Everyone else has 2-story homes, and their lots, their footprint are much deeper than ours. So, they can stay within that 30-foot setback.
And again, I think if you look through the neighborhood, they vary. On our side, there's some 30s. On the other side, there's a 6-foot setback. And where there is nobody behind us, as you can see from the slide that's on there, there's got to be between us and the properties behind us. It's all wooded to begin with. And there's probably 200-300 feet behind us that we can't see the neighborhood behind us and they can't see us. So we are not creating a problem with any abutting properties. But listen, we appreciate your time and thank you so much.
Great. Thank you, Mr. and Mrs. Gentile, right? Am I saying that? Okay. Yes. Thank you very much. Thank you. Okay, great. Board members, do you have any questions for the applicant? Oh, okay. All right. Okay. Well, thank you very much, Mr. and Mrs. Gentile.
You're welcome.
You're welcome.
Great. Okay. Okay, board members, do you have any other questions for Lisa before we move into deliberations? All right, great. Okay, so now we're going to move into deliberations. And just a reminder that city staff nor the applicant can speak during deliberations. So I'm going to start with the first board member. I see on my screen here is Ms. Long. Ms. Long, what are your thoughts?
I'm inclined to go with the staff recommendation, and that would be the approval of the 6-foot variance and denial of the second one, the 25% encroachment.
Okay. All right. Mr. Floyd?
I'm inclined to agree with Ms. Long and vote to approve the first variance and deny the second variance. My issue with the second variance is I just don't see what the unnecessary hardship is. I mean, I appreciate the homeowner's position, but I think, you know, the board has certain criteria that they're required to apply. And in order for us to grant a variance, we have to find that there is an unnecessary hardship. And it'd be one thing if it was like, we can't have any deck, but to say that we can have a 18-foot deck, but not a 22-foot deck, that difference to me doesn't, in my opinion, doesn't create an unnecessary hardship, the loss of 4 feet on the deck. So, as I said, I mean, that to me is the deciding issue on the second variance. So I'd vote to approve the first one and vote to deny the second one.
Okay. Mr. Williamson?
I would agree with John. I think my only hesitance is are we setting some sort of precedence by approving the first one and not the second? Just because there is no impact by the extra 4 feet, it would seem. But I mean, I'm inclined to go with what staff would recommend. But my fear is that by giving one, are we sort of opening ourselves up for needing to grant the other?
Yeah, understand. And Mr. Ragul?
Yeah, I do concur with Mr. Floyd. I do agree to approve first one, but I'm inclined to decline the second one.
Okay. All right, great. And for me, I agree with the board members to approve the first one and deny the second one. Okay. All right, great. Now we close deliberations and now move to voting. Is there a motion on the floor to approve the first variance of, I don't know if I need to read the whole thing, but to approve the first variance and then deny the second? And Ms. Sanchez-Myers, am I saying that correctly? As far as a motion, I'm just asking if there's a motion to approve the first variance and deny the second. Do I have to read out exactly what's in the finding facts of law? I mean, above the staff recommends.
I would just clarify when you talk about the first variance versus the second variance, maybe what's listed
Okay.
To approve the variance for a 6-foot variance from the 30-foot side, et cetera.
Okay. Got it. Okay. All right. Is there a motion for the approval of the 6-foot variance requested from the 30-foot rear yard for compliance of the existing principal structure, and a denial of the variance requested from the 25% encroachment allowance to allow a proposed deck to encroach 53% into the required 30-foot rear yard? Is there a motion is a motion to approve for the approval of the 60-foot variance and a denial of the variance requested from the 25% encroachment allowance?
Just to kind of make it simpler, can we do it as two separate motions? I move to approve the variance seeking a 6-foot variance from the rear yard setback requirement.
Long seconds that.
Okay. Motion has been moved by Mr. Floyd and seconded by Ms. Long. Now we'll go into a roll call vote. Mr. Floyd?
Floyd, yes.
Okay, Ms. Long?
Long, yes.
Mr. Raghu?
Raghu, yes.
Mr. Williamson?
Williamson, yes.
Okay, Wilson, yes. Okay. Now, and Mr. Floyd, thank you for making that more simpler for me. Is there a motion to approve the denial of the variance requested from the 25% encroachment allowance to allow a proposed deck to encroach 53% into the required 30-foot rear yard?
I move to deny the variance from the 25% encroachment allowance to allow the deck to encroach 53%.
I second that.
All right, motion's been moved by Mr. Floyd and seconded by Mr. Raghu. Now we'll go to a roll call vote. Mr. Raghu? Mr. Raghu?
Yes. Raghu, yes.
Okay. All right, great. Mr. Floyd?
Floyd, yes.
Okay. Mr. Williamson?
Williamson, yes.
Okay. And Ms. Long?
Long, yes.
Okay, great. All right, now we're going to look at the finding of facts and law and conclusion of law.
Mr. Chair, did you
Yes, ma'am.
on the last one? I'm not sure I caught your vote.
Oh, I apologize. Yes. Yes. Wilson, yes. I didn't see anything that needed to be changed. Board members, do you see any changes that need to be made to the finding, facts, and conclusions of law? If not, is there a motion?
Motion to approve the findings of fact and conclusions of law.
Okay, motion has been moved by Mr. Floyd.
And I second it.
Okay, and seconded by Mr. Raghu. Now we're going to do a roll call vote. Mr. Raghu?
Yes.
Okay, Mr. Floyd?
Floyd, yes.
Mr. Williamson?
Williamson, yes.
Okay, Ms. Long?
Long, yes.
And Wilson, yes. Okay. All right, now we're moving to the appeal. Ms. Sanchez-Myers, is this going to be similar to any case that we do, same setup and everything, or is there any differences when we're doing an appeal?
So the format is still the same, sworn testimony, and kind of just follow the general procedures that the city will, I believe, be presenting first. And then just, give the parties the opportunity to present their cases, questions from board. Yes, so the procedure is very similar.
Okay, all right, great. All right, so our next case is...
Mr. Wilson, if I can stop you first. I
Yes,
have
Ms.
a
Lamb.
conflict at 12:30, and I apologize. I let Terry know, so I don't know what that
Okay.
does.
Good question. Terry, I guess it's a question for Terry and for Ms. Sanchez-Myers. If we are still debating this case at 12:30 and Ms. Long leaves, that's going to affect our quorum. In that event, we wouldn't be able to vote. We would have to just listen to the case. Am I correct?
So I'll go ahead. So, yeah, Ms. Long would not be able to vote unless she were present for the entire presentation. At that point, we would still have 4 members present for the entire case, and quorum is 4 members. So the board I believe just requires a vote of 3 to pass, for an appeal to either affirm, reverse, or modify.
Okay, great. And I know we're pressed for time. Do I have to ask, I don't know if the applicant is here, if they would be okay with 4 members? Do I have to ask that? I just want to make sure before we get started.
I have a conflict at 12:32. Sorry.
Okay. All right.
Well, to answer your question, I don't think it doesn't sound like it matters at this point. But the board can proceed, with a quorum of 4. I know it's the board's practice, at least for variances, to inform the parties that there are only 4 members and give them the opportunity to request a continuance or deferral. I'm not aware of how that's been applied in the past regarding appeals. As I said, only 3 votes are required to take action. But it sounds like we're going to lose a
Okay.
anyway. So.
Okay. All right.
All
right.
Mr. Chair, I know, I guess one question I would ask is it possible to reconvene the hearing later on today? I don't know what the conflicts the other members have, but I think, that's one question that someone has raised in the chat.
Okay. That is a option. I know you're right. I'm not sure what the other board members are, they have any other conflicts later today. And then we would not, well, first let me stick with that question. Board members, do you have any problems if we were to reconvene later today to hear this case? If so, what time, et cetera?
This is Marshall Weaves, and I got a conflict from 2 to 2:45, but otherwise I'm available.
Okay. All right. Ms. Long?
I'm available at 3:30 and until whenever, so.
Okay. I'm looking at my schedule too as you all are speaking. Mr. Floyd?
Yeah, I mean, I'm conflicted after 4:30 today. I've got stuff scheduled from 4:30 to 6:30.
Okay. Mr. Ragu?
I am available after 4.
Available after 4. Okay, but not
Correct.
But you're not available before 4, right? Okay. I just want to make sure
I'm not
I'm
available
getting.
until 4. Yeah.
Okay. And I am not available between 2 and 2:45, but between now and that time, and then after, I'm available. Okay. And then the other option would be, and I don't know if this is actually an option, would be moving it to October. But again, I don't know if you can listen to appeal. This isn't like no normal case. So I'm not sure, Ms. Sanchez-Myers or even Mrs. Gray, Mrs. Hagler Gray, if we can actually do that. I'm trying to make sure I just weigh both options here.
Yes, so I believe that if the board loses quorum, then the procedure is that it's just set for the next regular hearing or meeting date. But
okay,
Terry, please feel free to weigh in based on your experience.
Okay.
Yes, I mean, if Ms. Sanchez-Myers is correct, if we don't have a quorum, or if you all don't have a quorum today, then the case would have to be continued to the next meeting in which you have a quorum. As you stated earlier, Mr. Chair, you may ask the applicant if they are willing to proceed with 4. I don't know if you'll be able to get that with all the conflicts today, but I think it's a question to be asked of the applicant, and also to see if there's a time frame when you can get the hearing, if it's possible to get a hearing scheduled with at least 4 members later today.
Okay. All right. I see that Mr. Murray is on screen here, and I'm not sure, Mr. Murray, are you involved with this case? And if so,
Yeah, Mr. Chair,
yeah.
I represent the property owner, so this is kind of a unique case. there's an appellant, Mr. Gatewood, who I'll let him speak for himself. I don't represent him. I represent the property owner. Mr. Spencer made an interpretation in favor of the property owner, and so Mr. Gatewood is appealing that. So that's an appeal. I'm currently talking to my client right now. My question is there a window today when there will be 5 board members? Because it was a little bit confusing, to be honest with you. And then my other question is there a situation where this wouldn't have to wait till October? Can there be a special meeting or something like that if we can't do it today?
Thank you for your question, Mr. Murray. Mrs. Sanchez-Myers and Mrs. Hagler-Gray, what are your thoughts on that, on what Mr. Murray suggested? Could we actually have this case at another day? It would have to be this week then, because, you know, October starts on Friday. So, yes.
So the board can conduct a special meeting, and I believe, and Mr. Murray, correct me if I'm wrong, I believe, I think his request was just before the October 28th meeting, not necessarily before October 1st. Is that right?
Sorry about that. I mean, obviously as soon as possible, because this has already been continued once. So it's now been, and again, Mr. Gatewood can also speak here. He's the appellant. But I think it's already been continued once. So obviously we want to go forward. I think nobody thought that these morning hearings were going to take so long. So,
and I was taking notes. Oh, go ahead.
Hello? Yes, can you all hear me?
Yes, just one, I believe that's,
This is Gatewood, Joseph Gatewood.
yes.
Okay, now we've been here this morning since 8:50, 8:56. And we got here early this morning in order for this case to be handled. And of course, we've been talking about putting it off long enough just about to have the case. So, and of course, and I've already given up all of my day, so it's not a possibility for me to come back in today, because I'm a self-employed businessman. So if you all are inclined to put it off to another date, that would be something we have to come to an agreement with Mr. Jefferson and his representative and us. But I think at some point we need to get this behind us. We've been pushing, continue once.
Okay. All right, thank you, Mr. Gatewood.
Mr. Chair, I did confirm with my client that, you know, given that this is an appeal, having 5 board members is necessary here, I think.
Okay, so he wants to have it with 5 board members. Am I hearing you correctly?
Yeah.
Okay. All right. Okay, Ms. Sanchez, you was about to make a comment.
Yeah, I was trying to take notes, and I believe that the only window where 5 members would be available is between 4 and 4:30. So I know that's not a lot of time. Mr. Ragu is not available till after 4, and then I have Mr. Floyd's not available till, he's not available after 4:30. So that, and the couple board members have to go very shortly within the next 10 minutes.
Okay.
I mean,
all right.
The other issue I'll raise there is, as I talked to you about this morning, Jill, I mean, I don't have a conflict with this. I do think I need to make some disclosures that might impact whether or not the appellant or the respondent actually want me to sit on this panel. And I'm happy to talk about that now, but if you know, the request is to have 5 board members. 1, I think it's unlikely we could hear an appeal in 30 minutes. And 2, I'm not sure whether or not I would even be somebody that you would want on the panel. So.
So why would that be? Why you couldn't be on the panel? You're suggesting a conflict of interest?
I'm having trouble hearing.
I believe that's Mr. Gatewood. He was asking why couldn't you be on the panel, and I'm not. Can he ask that right now, Ms. Sanchez? I just want to make sure I'm following the rules here. He can't. Okay. Can he? All right. John, he was just
conflict of interest.
Yeah, I don't see any, well, I think Mr. Floyd was going to explain the situation
Okay.
anyway, and then I would like to just weigh in as after he presents what he wants to present.
Yeah, so as some of the members of the board know, and I think Mr. Murray knows, and certainly members of the staff know, I am a practicing attorney here in Charlotte. I work for a large law firm. I actually do a fair amount of land use and zoning work. Given my role on the board, I typically do not take cases involving the city of Charlotte. And I don't have any involvement with this particular case. I also, anytime a case is going to be before the board, I make sure to run a conflicts check and ensure that it is not a client of the firm or anyone that any of my partners have worked with that are appearing before the board. So this is not a situation where I have some actual conflict with the matter. The issue is that typically when matters come before the board members do not run out and go do their own research and try to find out information about the subject matter at hand. And I did not do that in this particular case. I didn't know what the issue was here until this morning when I woke up and started reading the materials in preparation for the hearing. However, I have another matter that is ongoing right now in another jurisdiction. And that matter specifically relates to the issue of common law vested rights. And in fact, I have spent significant time over the last couple of weeks researching the issue of common law vested rights and, reviewed David Owen's book that I believe portions of were provided to the board on vested rights. I've reviewed the case law cited in that. And so I just wanted to disclose that I have, let's say, an abnormally high amount of information about vested rights that, is not something that you would normally expect a board member to have coming in and making this type of decision. And obviously I can't, I certainly think I can be fair and impartial, but I do have that information that is in my head. And so it's something I wanted to make clear to both parties before, the proceeding moved forward.
Okay. All right, great. Thanks, John. And Mr. Floyd, for the sake of time, we got 5 minutes before we lose 2 of our board members. Let me suggest this. Let's go ahead and pick a day this week that we can hear this appeal. I'm thinking maybe a Thursday, maybe Thursday morning, maybe say like 10 o'clock to hear just case only. I'm just throwing that date and time out there. I don't know Mr. Murray and Mr. Gatewood and board members, and of course city staff. I want to be, respectful of your time as well. If that day and time would work. If not, then the other suggestion would be for board members to email, as well as Mr. Murray and Mr. Gatewood, to email Terry within the next hour, a day and time this week that we can have this appeal. But those are my 2 options I'm presenting there. So first option is looking at a Thursday, September 30th at 10 a.m. to hear this case only, or we will just have to send Terry Edwards our recommendations for a meeting this week.
This is Shad. I want to go ahead and just say in the rules of procedure, and maybe this is something Jill can chime in on too, but it does say special meetings of the board may be called at any time by the chairperson. Notice of time and place of special meeting shall be given at least 48 hours prior to the meeting by the clerk or by the chairperson to each member of the board. But maybe since each member of the board that would be present are already present, maybe the 48 hours isn't as important, but I'll let Jill chime in on that.
Thank you. Yes, Shad is correct that it requires the 48 hours And I would, unless all board members would agree to waive that notice.
Jill, I think that there's a possibility that you can open this hearing and continue it. That's dependent on whether the parties agreed to have Mr. Floyd sit on the panel.
And so I think that's a great point. And actually, I was just thinking as well, but there are also public notice requirements for special meetings. And I don't know that the board has the ability to waive, I believe for special meetings of boards, it's the 48 hours required for public notice. And we're now past that 48 hours. Thoughts on that?
Yeah, for a special meeting.
I need to look at the 160D because I thought there was something in there that talked about if we didn't have a quorum or we couldn't have it, you would state when the meeting was in the hearing, and then you wouldn't have to provide mailed notice because the folks who were involved are participating currently. So notice would be given. I need to.
Can we, Mr. Chair, you might want to get a determination. I know you've got 2 minutes before you lose board, but you might want to get a determination about whether the parties have an issue with Mr. Floyd serving, because that might help us determine whether we can proceed with these 5 members, or we'll have to have an alternate sit in.
And I did want to weigh in on that, Mr. If I may, I'll be really quick. Mr. Floyd did bring that to my attention this morning. And I do believe that if a board member has specialized knowledge or special knowledge of general facts, that can be considered, and it's not any kind of automatic conflict of interest. I just recommended that it needed to be disclosed on the record to the parties, so that the parties have the, for full transparency, and that the parties have the opportunity to present any information or in opposition or in rebuttal to that those specialized facts or knowledge. It's a little unique because it's a knowledge of the law. But I do not believe there is a conflict of interest in this particular case with these parties.
Okay, so Mr. Murray and Mr. Gatewood, would you be okay with Mr. Floyd when we do meet serving in his capacity as a board member, given what he has said today, that he may or may not have a conflict of interest?
I don't have a problem with him being on the board.
Okay. And Mr. Murray, it looks like you're still trying to
Mr. Floyd, are you representing a landowner or government or what?
I'm sorry?
This case that you're working on, are you representing a landowner? Are you representing government, or what? What's the?
I'm representing the developer.
Okay. And who's it against?
The town of Harrisburg. It's not an active matter. It is not in litigation. It is pre-litigation.
Okay.
Thank you. Thank you for asking that question. Because if he is he's representing a developer, that may create a conflict on our side.
Is there a way to reduce your volume? Because our court reporter's having problems hearing those statements.
Is that better? Is that better?
Chad, is that better for you?
Maybe a little bit.
Can you hear me?
Yeah, we can hear you, but our staff in the government center is having a hard time making out what you're saying. And I believe that Mr. Gatewood was saying that if Mr. Floyd is present during the appeal, given that he represents the developers, it may cause a conflict of interest in his eyes. And Mr. Gatewood, did I summarize what you were saying accurately?
Yes, that's correct.
Okay.
And
Did
let
our
me just be clear. I mean, I'm certainly fine to not sit on the panel, but I did not disclose a conflict of interest. That is not what we're talking about here. I have no financial interest in this proceeding or anything else. It is just a matter of I have specialized knowledge about the subject matter.
Okay.
Let me just say one thing, because I don't know if the other board members have left yet. But I did find that for, in 160D, it talks about, clarifies that an evidentiary hearing on a quasi judicial matter may be continued in the same manner as currently allowed for legislative hearings. If the time, date, and place of continued hearing is announced at a duly noticed hearing that has been convened, then no additional notice of continuation is required. So if we open it, announce the date and time, then that would be sufficient according to 160.
Okay. All right. And so there isn't a 48-hour required time period like we mentioned earlier. I mean, I think we're already into 48 hours. It's Tuesday. If we went by Thursday, well, kind of, sort of. But
I think it's as long as you open this, as long as you open it and continue it and don't, that's why it was necessary to make a determination about Mr. Floyd, because the applicant, because one of the property owners, one of the parties is saying they would prefer a 5-member board. So I do think that it would probably be necessary to make sure that if you open it, that you have the same members present at whatever the next meeting date is. But I don't think you have to have that 48-hour notice if you open it and continue it to a date certain.
all right. So right now, Mrs. Long has left, and I don't know if Mr. Ragu has left as well. So if that's the case, I wouldn't be able to open it and continue it, correct?
Oh, yeah. Did they leave?
Yeah, Miss Long put in the chat that she jumped off, where she can make herself available Thursday or Friday if necessary. Mr. Ragu, are you still there? I think he's already gone as well. So from what I've heard from some staff, and I just want to be respectful for folks' time here, that as chairman, I could basically give the date and time, and then we can just go with that. Okay, all right. So I would propose that, and if both, you look like you're about to say something, Ms. Hagler.
Yes, I would support what you said earlier as one of your options. Is what we typically do is have the board members indicate to the clerk, Terry, what times they are unavailable. Say if you're trying to get it done this week, what times they're unavailable. Also, the applicant, because I think he indicated he had some time constraints. And once you get that information, you can call the special meeting.
Okay, all right, great. All right, thank you very much for that. All right, so let's just go with that. So board members, I guess, Mr. Edwards, could you just email the board members as well as the applicant, of course, separately, and just ask what their availability is. It seems like everybody would like to get this done this week, given that it has been pushed off. I shouldn't say pushed off. It has been rescheduled at least once or twice now. So can the clerk do that?
Yes, I'll go ahead and get everybody looped in, find out.
Okay.
And if I understand correctly, the applicant is objecting to my appearance, which I'm fine with. So I will not sit on that. And that means that Deborah Dryden will need to make sure that she's available. Is that correct?
Yes. I believe that's correct. City attorneys, is that both city attorneys, is that correct? And that's a good point, Mr. Floyd, bringing that up, that Mrs. Dryden is a board member and she couldn't make this meeting.
Go ahead, Jill.
I was going to say, if you could give me 1 second, I don't believe, but
That would be correct.
I believe that the board, okay, so
when there's a challenge of an existence of a conflict of interest that may be presented to the board by an interested party, that sounds like what this applicant is doing, and that the zoning board shall hear the evidence and by majority vote make the final determination as to the existence of a conflict of interest. So I just do want to remind board member Floyd that he's not required to withdraw or recuse himself, and I would discourage sort of blanket recusals just because of maybe the occupation of the board member, those kinds of things. And I would suggest that the board consider whether there's a conflict of interest for Mr. Floyd serving.
Well, I mean, look, I don't typically consider a conflict simply because I'm a lawyer and we handle variances. My issue here is this is a very specific area of the law, and I've literally spent probably 10, 15 hours over the last 2 weeks researching this specific issue. And so, you know, it's not a blanket every time a case comes before the board. I'm concerned. I had the concern, I raised it. I think the applicant raises the concern. And so based on that, I'm going to voluntarily recuse myself. I just think that makes sense rather than creating some potential appeal issue here. We already have 5 other members of the board that can hear this. So I just think that's the best way for this to move forward.
This is Chad. I do want to add, I believe Miss Dryden is like out west traveling, and I think that's why she's not able to participate. And I think she was going to be gone for quite a while. I don't know when she would be back.
Damn it. Sorry, I didn't mean to say damn it. My bad. I know the court reporter don't record what I just said. I'm sorry, but don't put it in the record. Okay. So, I'm sorry. No, Mr. Gifford, what did you say?
Can I speak? May I speak?
Oh, may you speak? Yes. Okay. I thought you said last week. I'm sorry. Yes.
I'm sorry I'm not picking up when logically astute as perhaps some of you all are. We had trouble getting on this Zoom this morning. At any rate, I don't particularly have a problem with Mr. Floyd. Because I would like for someone, you know, to know something about vested rights. So I don't really have an issue with him. I previously said that because he was representing the developer, and of course our issue here is not necessarily with the developer. Our issue is with the zoning administration as to the way that they're applying the code. So I just wanted to put, you know, so
okay.
Back, I'm sure if now Mr. Floyd wants to recuse himself, because that's his individual preference. But I don't particularly have an issue with him. Someone who knows something about vested rights.
All right, John, Mr. Floyd. So Mr. Gatewood is basically saying he doesn't have a problem with you serving, you know, on the board for this case. Would you feel comfortable hearing the appeal, given now that Mr. Gatewood says that he doesn't have a problem with you being on there?
Yeah, as long as Mr. Gatewood and Mr. Murray don't have any objections, I'm fine serving on the panel. But if either one of them has an objection, I think it's appropriate for me to recuse myself.
Okay. And I don't think, yeah. I'm sorry, Mr. Murray, go on.
That wasn't me. I was just saying at this point, I don't have an objection, but if I wake up at 2 a.m. and I have an objection, I'll let everybody know.
Okay. All right. So I think we have a way forward here. So the clerk will send out an email to the board, of course, to the applicants, find out when they are available to meet. I think everybody's in agreement that we should do it this week since it's been rescheduled quite a bit now, and we will be able to go from there and so forth. So I think we have that settled. All right, Mr. Murray, Mr. Gatewood, thank you, but also we apologize for any inconvenience this may have caused you. Case. All right. Board
I'm
members.
sorry to be the chink in the armor here, but if we never actually convened a hearing, we're not actually, or we never opened one, we're not just continuing one. So do we have to meet the notice requirements?
I think we do have to meet the 48-hour notice requirement now that we lost the quorum for the board.
So basically we would be looking at Friday, the earliest.
Can we, Mr. Chair, you may want to ask the property owner and Mr. Murray if early next week is a possibility as well.
Yeah, Mr. Murray and Mr. Gatewood, do you have, next week is October. So do you have any objections of meeting early next week, which is the week of, okay, that'll be the week of October 3rd/4th.
I don't have any objection to meet next week, or that will give me more time to read over the findings of facts, which I just received this morning at 8:37. So
okay,
I don't have a problem with meeting next week.
Members of the board, I do have I've a hearing scheduled with the Department of Transportation on the 5th at 10 a.m. So that is a conflict for me on the 5th. I'm open on the 4th, and it looks like I have a hearing on the 6th at 10 a.m. also, but I can check on what exactly that is. It looks like it's another condemnation case.
Yeah.
But 7th and 8th wide open if we have to go that far, but 4th wide open. Afternoons on 5th and 6th are wide open. 7th and 8th open.
Okay, duly noted. Okay, so I think that we have a good way forward here. So we're looking at sometime next week then, if I'm hearing everybody correctly. Okay.
Do we have any estimate of how long the hearing might take? I mean, I know some appeals can go for hours and hours. Is this a shorter one as we think about scheduling?
City attorneys, I don't know, Mr. Murray, I don't know who would answer that, city staff.
I think it's probably going to go longer because there's probably going to be 3 presentations. The city's got a presentation, the appellant has a presentation, and the landowner has a presentation. And then obviously back and forth, I assume. So.
And I would probably allocate a couple of hours, at least 2, to be safe, 2 hours, David.
Okay, that's good to know. Okay. All right. Okay, great. Any other questions for this appeal case? Before, the only thing we have on the agenda next is the approval of the minutes from August.
I don't think we can do that because we don't have anybody left.
That's right. I forgot about that. So that's going to be pushed off too. All right, great. So, okay. So I guess that's it then. All right. So before we adjourn, I just want to again thank the board members for sticking in today. I know it was a long day, and also I don't know if we have ever said this before, but definitely thank you, staff members, for all the hard work that you guys are doing. I know it's tough. You've been doing this virtually now since COVID hit. I don't think you have seen us in like a year. And we thought we were going to see you in July, but then the Delta variant came out of nowhere. So thank you for your hard work with everything you guys are doing with using the virtual world and everything. So yeah, thank you very much for that. So I can't even adjourn the meeting, right? We can't even have a vote to adjourn, right? I mean, we just have to hang up, right? Basically.
I think, yeah, just turn it off. No, I think you can adjourn the
You
meeting.
can,
Okay, all right, okay, great. So this meeting is adjourned and we will see you sometime next week, I guess. So, okay, all right, thank you very much.
Thanks, everybody.
Thank you.
Okay, bye-bye.